Item number 3. Document 468 of 2016.
The appeal is you're for the department.
I am for the department.
Ah,
State Commissioner from the department. sir.
Ah.
You are from my.
Yeah, so let's.
none appears for the petitioner.
They matter.
Your appearance will be noted. None appears.
Madam, this matter is covered, well covered by your lordships in an analogous matter.
Oh, I see.
By order dated 26/7.
All right. In view of the,
Kindly have a glance.
yeah,
The
yeah.
same order is passed. Maniraj is also dealt with.
Whom are you appearing for? Whom are you?
I am for Central Exchange.
Central Excise. All right.
P.K. Panda. P.K. Panda.
P
for Puri.
all right.
The same order is to be passed by, that's all. Clubbing up and limitations, both they cannot be marked.
All right. In view of the order passed by this court on 26 July 2022 in CEREF number 4 of 2003, the present reference case is also disposed of in the same terms. All right.
I follow you.
Item 2, sir.
Item number 2.
In terms of the same judgments been disposed.
My name may kindly.
Yes, please. Yes.
Item number 2.
Be permitted to appear through DC Miller.
All right.
In this case, if your lordship will come to the order of the Learned Sister, there are 3 orders. It starts from page number 18. Miller.
Right.
And if your lordship will come to page number,
No, is the issue alive, sir? Because it has not even been listed once in the last 18 years.
my lord, the issue is that the respondent has produced some railway receipts. There is a,
We can leave the questions open, sir. The reference was not even listed once.
that's true, my lord. My lord,
We
kindly-
leave, because it's a stale matter now, sir. We leave the questions open for decision in some other appropriate case.
My lord, I'll beg your lordship to kindly turn to page 30, my lord, where the Learned Tribunal has, after observing certain points, has set aside the appeal to reconsider the same to the adjudication of authority, my lord.
Sir, in 18 years, either that has already happened, in which case this is infructuous. If it has not, it should happen now. Because in 18 years, if the status quo has continued, that itself is the reason not to interfere.
Yes, your lordship. Then kindly turn to page 49, my lord.
Right.
There is an order passed by the judicial member where he has allowed the appeal. Running page 49, my lord.
Yes.
Then it has been referred to another technical member because there is that technical member also allowed the appeal. So the issues has to be decided by your lordship.
We'll leave the questions open, sir. You say in the last 18 years, the present reference case was listed not even once. Full stop. By the impugned order of the tribunal, the matter has been remanded to the adjudicating authority for a fresh decision. Full stop. Counsel for the petitioner is unable to inform the court whether pursuant to the remand, the proceedings have already concluded. Full stop. In which case, the present reference be rendered infructuous. Full stop. With no order having been with the matter not even having been listed once, and therefore there being no stay of the remand proceedings. The matter, the present petition has been rendered stale. Full stop. All that the court can observe at this stage is that the questions of law arising from the impugned order, as urged in the present petition, reference petition, are left open for decision, if any, in some other appropriate case. The reference petitions accordingly disposed of.
I pray, my lord. May I pray, my lord, one thing, my lord. My lord, the reference application has not been settled on majority. It has been allowed, my lord, the appeal. On majority, the appeal has been allowed.
Sir, you have filed this reference.
My lord.
Are you aggrieved or you're not aggrieved by the impugned order?
Agreed by the impugned order.
So to the extent you're aggrieved, we are not interfering. We are allowing whatever has been passed to remain, sir. All right. All right.
Weekly list item number 3.
None appears dismissed.
Item number 4. The Lordship may kindly remember on the review petition, your lordship was pleased to recall the order and matter is restored to file now, lords. Petitioner in this case has challenged the recovery proceeding, by annexure 9, 11, and 13 issued by the revenue lords in respect of the due to the erstwhile Srinadhara Industries. And I have purchased the industries of Srinadhara by order of the debt recovery tribunal in auction. This matter is directly covered by a judgment of your lordship, which I am giving to your lordship. Before that,
Koshali Cement.
yes, in the case of this petitioner, what has happened? Your lord, the entire the case of the revenue in that case has that they say that it is transfer of property. So that is how you are being the transfer, you are liable. Section 1 of the Orissa Sales Tax Act. And Section 91 envisages there must be absolute transfer, complete transfer. And for that, matter has gone before the revisional authority, and your lordship have also in paragraph 2, your lordship can see. My lord referred to the revisional authority order, where the revisional authority said that you must gather information because there is no information available to you to justify or to satisfy complete transfer of property. So therefore, your lordship have said that nothing having been gathered since last 18 years, you can't thrust upon the demand on the transfer is saying that is transfer mode. I am reading you before lordship paragraph 2 of my lord's order.
Yes, I got that. No, are the facts here similar?
Your lordship,
Similar, and one more addition. Now they are justifying the demand in the counter affidavit. I have gone through detail. They say that this 19(1) and also 13(b). 13(b), the revenue says because it's a fast charge, bills, so therefore you are liable to pay. My humble submission is that there is also a judgment of this honorable court. Your lordship have said fast charge bills in respect to property bills, that is the recovery from the either from the transferor or bills the person being the in the case of your lordship is dealing with a matter where under the state finance corporation act bills under section 29 state financial corporation has bills invoking 29 has seized the assets and bills put to action and the revenue bills has clamped 13A this fast charge invoking this fast charge provision against the bills the Odisha State Financial Corporation, and in my case auction has been conducted by the Orissa Debt Recovery Tribunal, and your lordship said money can be recovered from State Financial Corporation, not from the purchaser bills.
Right.
And if your lordship will see, kindly may take your lordship's attention to statutory provision. My lordship, kindly see for a moment. The Orissa Sales Tax Act, 13A1. First 13B, then I will take your yes, 13B.
Your lordship, I am appearing through BC.
No. After he finishes, sir.
Yeah,
13B of the Orissa Sales Tax Act.
Yes.
Notwithstanding contained in any law for the time being enforced, any amount payable by a dealer under this act on account of tax penalty. Sir, your lordship got it, the provision? 13B, my lord. I'm sorry. 13 capital B, my lord.
We've got that. Tax to be first charge on property.
Yes, absolutely. Notwithstanding anything to contrary, contained in any law for the time being enforced, any amount payable by a dealer under this act on account of tax, penalty, or interest on or any amount which a person is required to pay under Section 13A or for which he is personally liable to state government under subsection 4 of the said section, or any amount which a person required to deduct and deposit the government treasury under the provision of 13AA, shall you first charge the property of the dealer or such person as the case may be. But this 13B refers to required to pay under section 13A1. Now your lordship may kindly turn to 13A1. What it speaks. Special mode of recovery. My lordship kindly. 13A1, my lords. Notwithstanding anything contained in section 13 or any law or contract contrary, the commissioner or any officer appointed under subsection 3 of section 3 may at any time from time a notice in writing, a copy of which shall be forwarded to dealer at his address last known to the officer issuing notice require. Any person, sir, these are two parts, my lords, A and B. Any person from whom any money is due or may become due to a dealer who has failed to comply with a notice served under subsection or subsection 5 of section 13 or has failed to pay an interest due from under this act. Because this small b I am skipping, it's not relevant. Because then your Lordship may kindly see who is the person liable under 13A4. Your Lordship may now kindly go to 13A4. Below. Any person discharging liability to dealer after service on him, the notice issued under subsection 1 shall, if the liability discharged in any manner other than that required sale notice, be personally liable to any sale.
No, I think the point is very simple. Since you have purchased it in an auction in DRT proceedings, you say the liability you have not taken over. Absolutely. Unless there is an inquiry to see whether you have taken over any liability, they cannot simply issue a notice to you making a demand.
Absolutely correct. And your Lordship will answer the question, Lord.
All right. Yes, Mr. Mishra.
Your Lordship, in that order, Your Lordship, which has been passed by Your Lordship, in that case, a revision petition has been filed against challenging the allow of registration, Your Lordship. That revision order has been passed, and in the revision order, there was a direction to make an investigation, Your Lordship, so far as whether enter liability has been transferred or not, Your Lordship. So these after investigation, Your Lordship, all these notices, since all these notices have been issued after 2 years of that order, Your Lordship, I may be permitted to take 1 week, Your Lordship, 1 week time, Your Lordship, to verify what is the starter, what is the report of investigation, Your Lordship. I am saying so, Your Lordship, why I am praying so, Your Lordship, in that order has been passed, revisional authority has been passed in the year 2003, Your Lordship, and subsequently 2005, in the year 2005, the impugned notices have been issued. Your Lordship may kindly turn to that impugned notice dated
9/11/2005.
9/11/2005, Your Lordship. So as per section 19(1), Your Lordship has already gone through section 13B and 13W. 19(1) of the Odisha Sales Tax Act clearly says that 19(1), Your Lordship may kindly turn to 19(1).
Yes.
When the ownership, as Your Lordship has already held, when the ownership of the business of a dealer liable to pay tax under this act is entirely transferred, any tax payable in respect of the business till the date of transfer and remaining unpaid at the time of transfer shall without prejudice to any action that may be taken for its recovery from the transferor be paid as if he were the dealer liable under this act for such tax. Your Lordship, at the time of
So that word entirely, if you now come to State of Odisha versus Raja Stores,
Your Lordship,
Raja Stores, they interpreted 19(1).
Exactly.
And this court said that the expression entirely has to be properly investigated.
Exactly, Your Lordship.
If it is not entirely transferred, then you cannot fasten this liability.
My Lord, exactly. I bow down, Your Lordship. For that reason, I may pray be granted because it is a clear case, Your Lordship. So for these notices,
3 and 4 of your Lordship judgment by Lordship kindly.
Your Lordship, I bow down. I don't dispute Your Lordship. Judgments are conscious.
I will pray Your Lordship, paragraph 3 and 4. Probably my friends request may of the old judgment.
No. So we recorded that he was not in a position to inform whether the investigation has been completed. Here he says, you give me time. So there he was unable to inform. Here he says, give me time to tell you has taken place.
If there was no investigation, then I have no case. If there was no investigation, no report, Your Lordship, I know Your Lordship, because after 18 years, this investigation cannot be done.
Correct.
So I just want to verify the investigation.
All right. At the request of Mr. Sunil Mishra, learned standing counsel with the department, who wants time to ascertain if any investigation was undertaken by the department to find out whether the business of the erstwhile industry SSC.
Snehadhara Industries Limited.
Yes, Snehadhara Industries Limited was single quotes entirely taken over by the petitioner. List on 14 November, sir.
Yeah, let's see, some more time because it is so old case.
That's the problem, sir. Older case means longer adjournment. It becomes an even older case.
Yeah, let's see. Yeah, let's see. Yeah, let's see in the first week of December. Can you let's see, please?
Lordship have said 18 years.
No.
My lords have clearly stated in para 4.
Correct. 21st November, sir.
Okay. Gratefully.
Old matter item number 5.
I'm appearing for the opposite parties, my lords.
All right.
In the meantime, the arbitrator has expired.
All right.
So connected matter, your lordship had said that since the arbitrator is already expired and it's an old matter, parties, if advised, may again approach the court in an appropriate.
Anyway, the appellant is not appearing. You say none appears for the appellant. Mr. Palit, learned senior counsel for the respondent, in fact, the term question is already expired. The appeal is
Justice P.C. Mishra.
Mr. Justice P.C. Mishra, former judge, has already expired. The appeal is dismissed.
Old matter item number 6.
Your lordship, item number 6, there are three revision application. 2 revision application is of the state and 1 revision application is of the dealer, your lordship.
Right.
Your lordship, here the question of law is at page 8 of the revision application, your lordship. So
what's the tax effect, sir?
Your lordship, tax effect is 10 lakhs, your lordship.
All right. Yes.
But prima facie on the face of the record, your lordship, two state revision, if even your lordship will allow the question 1 and 2, both the question will be allowed, then also the tribunal order will be sustained.
Okay.
Your lordship,
All right.
let me place your lordship because
All right.
third revision is of the petitioner, your lordship. So your lordship, SDP twine and SDP fishnet and PP ropes, whether will fall within the ambit of entry 23 of part 1 of the schedule appended to Orissa Anti-Tax Act, if it is an affirmative, consequently Orissa Sales Tax Tribunal has aid in holding that this goods should not fall within the scope of side entry. Your lordship, here the fishnet, your lordship, the entry 23 of the part 1, your lordship.
Anti-Tax Act.
(23) of the Schedule 1, Part 1. Polythene, high density polythene, polyethylene, polypropylene, including wove snacks, plastic goods, molded luggage, excluding plastic and molded furniture, your lordship. So here this is SDP, that same SDP, high density polyethylene, that is fishnet and PP rope. Everything is a plastic item and everything is of SDP. So this is taxable under this schedule, under this entry, your lordship. I may draw your lordship's kind attention to the tribunal's order, how the tribunal at page 21, your lordship, tribunal's order, learning tribunal's order, page 21. Page 21, paragraph 9, we peruse the orders of both the forums. Appeal memo, admittedly appellant brought SDP, twine SDP, so and so rupees 4 crore. State into the local area of the Cuttack for sale as per entry 23, so and so plastic good are accessible to anti-tax at the rate of 1%. SDP is a thermoplastic mode of petroleum. It is harder, stronger, little heavier. Polypropylene is a strong, flexible artificial material used to make things such as rope, carpet, and pipe. So SDP, polypropylene are different goods from SDP, twine. Therefore, SDP fishnet are not. Your lordship tribunal himself has said that it is SDP. Itself admitted, and tried to distinguish that it is not that material, your lordship.
Not material.
Not
No. The emphasis is on the words fishnet, twine, and rope.
Your Lordship. Your Lordship,
So these are all identifiable specific articles.
Your Lordship, that entry is also the same. Entry is also the high SDP, polypropylene, including open sac. And over, Your Lordship, first three entries, polythene, high density polyethylene, polypropylene, including open sac. So these goods are coming under the purview of that entry, Your Lordship.
Hmm. What has the tribunal done?
Your Lordship, the tribunal is allowed by that it is not coming under that entry, Your Lordship. These goods are not coming under.
What does the stay of such an order mean? I don't know. That they continue paying entry tax.
Your Lordship.
Have the other side been served?
Parties.
You're not audible or visible, Mr. Behra.
Mr. Behura, you unmute yourself.
Say your connection is bad. You are neither visible nor audible. I think we'll pass it over.
Item number 7.
My lord, in this case, the penalty has been imposed for non-submission of audit report under section 65 without affording any opportunity of hearing. My lord, on similar issues, my lord has passed this order. Similar order may be passed. My lord is directed by giving a fresh opportunity of hearing, then fresh order may be passed.
No, Your Lordship, here I may be permitted to place the counter. Two times focus notices have been issued.
Yes.
Your Lordship, a counter running page 13, Your Lordship. Internal page 2, running page 13. Paragraph 7, Your Lordship, paragraph 7, Roman 1. The petitioner was obligated under section 65 of the OBAT Act to furnish a report of the audit accompanied by a statement showing the closing stock in trade held at the end of the year, October, Your Lordship. For this purpose, the company petitioner was required to get it so and so. No such report was furnished to the opposite party. Has issued a show cause notice on 20th June 2011. Copy is enclosed as annexed. First show cause notice, the petitioner furnished a report. After show cause notice, the petitioner furnished a report on 25th August 2011 along with a reply to show cause. Copy of that reply also. Your Lordship may kindly
reply.
Paragraph 6, Your Lordship, 28/12/2000 again, the officer again issued another opportunity, another notice affording an opportunity to show cause. Why penalty shall not be imposed for
No, there was a second show cause notice for penalty.
Second show cause notice, Your Lordship.
Right.
And that notice, Your Lordship, said notice was served on the dealer. Since there was no response, then Your Lordship, order has been passed, Your Lordship. So two opportunities have been granted for in the against the first. He has produced that audit report, which has been done belatedly, and the second show cause notice. Why penalty will not be imposed since your explanation is not satisfactory or you are belated, and against that order has been passed, Your Lordship. So now another opportunity. What is the reason of another opportunity, Your Lordship?
Yes, please.
Yes, my lord. Lordship may kindly. I'll only speak from their annexer. Right. Annexer B/2.
Yes.
They have enclosed. Page 7. Right. Lordship will kindly see.
Right.
My reply. Dealer's representative para 1 has gone to your office on so and so date
that audit certificate dated 30th of September 2010, which was not accepted by the office. Then, my lords, that after 5/10/2010, the company has not received any so-called notice. After 10 months, the present notice has been received that the said audit certificate under Rule 73 is enclosed here too, that the company changed its name from Everest Industries with a 5/7/2003 and applied for amendment on 10/9/2003, which is still pending, even after requests made many times, whereas the returns are accepted in the changed name. That section 65(1) provides that the audit report should be in the prescribed form, whereas no such form. Lordship may kindly see, under there has been no form available under 73, Rule 73 sub-rules, my lords. Prescribed as your form has been defined under Rule 2H, which means a form appended to these rules. No such form has been appended to the rules. Only the certificate has been prescribed in Rule 73 as form of the certificate. That in the past year, controversy has been there, and most of the cases, no audit report had been insisted due to the above reason. That has the so-called notice immediately. The dealer could have submitted the same which is submitted today. That the procedure prescribed should be followed as per the Act and the rules, which decides the law. Nothing can be added or deducted in the list of forms. We are not, my lords, the allegation that they have afforded opportunity, they are, as per their submission, is totally incorrect. Admitted. But the question is, can an order of penalty be imposed without affording an opportunity of hearing? That is the sole question, my lords.
No. Here they say there was a second show cause notice for the penalty.
Which, my lords, the second show cause notice,
yes,
which has been given,
yes, C/2.
C/2. Yes, my lords.
You have not sent a response to this, then you cannot complain of no notice.
No, I am. Yes.
Without a response being sent, how do you?
My lords, this so-called notice, whether it has been served upon the dealer.
No, but no rejoinder filed, sir. So you have not disputed the fact that there is a second show cause notice.
Correct, my lords. Correct. Correct. My lords, I accept.
All right. The challenge in the present petition is to the imposition of penalty on the petitioner by 20th June 2012 under Section 65 (1) of the Orissa Value Added Tax Act 2004 (OVAT Act), read with Rule 73 of the OVAT rules. Full stop. Paragraph. At the outset, Mr. Rai, learned counsel to petitioner, sought to rely on an order dated 4th December 2021, passed by this court, in writ petition civil 12180 of 2012, Messrs. Koshala Udyog versus Commissioner of Commercial Taxes, where the penalty order was quashed since the mandatory requirement of a reasonable opportunity of being heard to the dealer was not afforded in terms of Section 65 (2) small b of the OVAT Act. Full stop. Paragraph. However, Mr. Mishra, learned additional standing counsel for the department, referred to the counter affidavit filed in the present case, wherein para 7 6, there paragraph 7 bracket 6, it is specifically stated that on 28th December 2011, the sales tax officer had issued a second show cause notice to the dealer as to why penalty should not be imposed for non-submission of the audit report within the stipulated period under the statute. Full stop. Therefore, paragraph, the court notes that there is no rejoinder affidavit filed to contradict the above averment of the department. Full stop. It may be mentioned that a copy of the aforementioned notice dated 2012-11 has in fact been enclosed with the counter affidavit as Annexure C by 2. Paragraph. In the circumstances, the court is unable to agree with the submission of Mr. Rai that the order passed by this court in Messrs. Koshala Udyog Supra would apply in the facts of the present case. Paragraph. There is therefore no procedural infraction of the requirement under section 65 bracket 2 bracket small b of the Overt Act in the present case. Full stop. The court notes that it is the case of the department, no reply was received to the second show cause notice. Full stop. With there being no rejoinder to contradict this averment, the court proceeds on the basis that despite a second show cause notice, the petitioner chose not to reply. Full stop. Consequently, the order passed by this court in Koshala Udyog bracket Supra will not assist the case of the petitioner. Paragraph, there being no other ground on which the penalty order has been challenged, the writ petition must fail and is accordingly dismissed. Right.
Grateful.
Old matter item number 8.
None appears dismissed.
Item number 9.
None.
Item number 10.
None appears dismissed.
10, I am for the opposite party.
All right.
Item number 11.
Item 11, my lord, I'm appearing on VC, my lord.
Yes.
There are 5 applications for substitution, 4 applications for substitution and 1 application for deletion.
Delay. 743. I 743.
My lord, sole appellant has died, and in IA number 37.
The delay is 486 days. In filing the substitution application and 446 days in filing the setting aside of abatement.
My lord, the substitution
application tried to give an explanation, sir, saying that there was a dispute amongst members of the same family,
yes,
and therefore the deponent was not supported by the others in filing such an application.
There's a dispute between the families. Actually, my lord, this
the delay in filing the appeal itself is.
Am I audible, my lord?
Yes, yes, please.
Yes, my lord. But the dispute actually is regarding a consolidation operation.
Sir, you have to give a proper explanation for the delay in filing the substitution application. The appeal has already stood abated because of the death of the appellant. You have filed 2 applications, one for substitution, the other for the setting aside of the abatement. Both applications are delayed by more than 440 days. The explanation offered by you in the applications for condonation of delay is totally unconvincing and inadequate.
Well, the sole appellant died on 21/1/2019. And the application was filed on 27/9/2019.
Sir, you have filled up the days. You don't make us now sit down and calculate. I am reading para 5 of your application. Do you have your application or you do not have it?
I have my, I have.
Will you kindly do us the favor of reading it, sir?
IA number
743.
739, my lord, for the appellant. That under the premises stated above, it is expedient in the interest of justice to condone the delay of 190 days in filing of substitution application and 130 of the setting aside of abatement.
What is 743?
743 is for the respondent number 4.
No, respond number 6.
Number 6.
Ah, even that is delayed only.
Respondent number 6 and respondent number 4. My lord, the death of these persons were not known for a long time, and there was a difference between the family members because this grandfather of the appellant, the father-in-law of the appellant, and after the death of the appellant, the legal heirs were not able to collect the record regarding when they died actually.
Let's see what is wrong with the impugned order of the single judge.
The page number 6. Well, the impugned order in the impugned order, the honorable single judge in page number 68, my lord, where the honorable single judge have quoted the judgment of the consortium officer. If I may,
para 7 of the impugned order is in para 7 of the
para 7, correct.
Page 69.
Yes.
If I may present the facts before your lordship, my lord.
Sir, we have not prevented you at all. In fact, we want you to argue it properly.
Well, the whole property was in the name of one Naimat Kalapahada. The area was 393 decimals. After the death of Naimat Kalapahada, it was divided between Raja Kalapahada and Laja Kalapahada. Equal shares, that is 96 and half decimals. That 96 and half decimals, there's a claim that there's a partition deed where the whole property was divided between Raja and Laja as southwest and northeast. However, the present appellant, the deceased appellant, was the wife of Raja Kalapahada, and Raja Kalapahada had given 196 and half decimals to Maitun Bibi, who is the deceased appellant, my lord. My lord, out of that property, it is alleged by the number 4 to 11 that we have sold the property of around 210 decimals to respondent number 12 to 17, respondent number 13 to 17, my lord. However, my lord, if your lordships may come to the sale deed that is in Annexure 1, page number 21, registered sale deed dated 27/10/1967 and 1968. It's in Odia. Here, the names of the vendors have been given. That the names and details of the vendors: Maitun Bibi, age 30 years, wife of Raja Kalapahada, and Raja Kalapahada, aged about 41. So the sale was actually of by both the Raja Kalapahada. So the sale was of the whole property, out of the whole property. However, the respondent number 41, respondent number 4 to 11 have alleged that as Maitun Bibi had sold, there was an amicable settlement, there was a partition. So as Maitun Bibi had sold 96, 210 decimals out of the whole, out of her share, and she had sold more than what she had. However, my whole share was acre soon 393 decimals. So the remaining part was 183 decimals. So my lord, then after that, this Raja Kalapahada had sold 35 decimals to one Kartika Sethi. So my lord, the remaining part what Raja Kalapahada had was 56 decimal and half. However, by a sale deed, Raja Kalapahada had sold 196 and half decimals to his wife Sabiran Bibi, who was the deceased respondent number 12. Which is clear, my lord, that the respondent could not have sold that property because he did not have that much. He only had 56 and half decimals, out of which he, because that RSD dated 18/12/1968 is a sham, and because of which only respondent number 4 to 11 has only 56 and half decimals of properties, which the consolidation authority, my lord, failed to understand, because the respondent number 4 to 11 actually submitted that there was an amicable settlement and between Raja and Raja Kalapahada, there's a registered partition deed which was worked out. Hence, the property which was sold by Maitun Bibi is not part of the property which was there for sale for respondent number 4 to 11. So, my lord, the appeal to the consolidation. Annex of 4, my lord.
Mr. Panda, you will have to hurry up. You seem to be in a sleep mode today.
I'm extremely sorry, my lord. My lord, because we have a right over the property, that property which was sold by Mr. Laja, the wife of Mr. Laja Kalapahada, who was Sabiran Bibi, respondent number 12, my lord, there is no chance that this person, that Sabiran Bibi would have sold more than what she had. My lord, that the paragraph, my lord. that the settled position of law comes into play that consolidation authorities cannot ignore such registered deed of partition so long as it stands and simply because it has not been acted upon. Even if it is so found, the consolidation authorities have no authority to ignore it altogether as having no force in the eye of law. My lord, this is a settled position of law. However, my lord, after that partition, there was a joint sale by both the parties. So, which shows that the party, while making these registered sale deeds, by Annexo 1 and 2.
Yes. How does one avoid the partition deed, sir? That's the whole question.
Pardon, my lord?
How can one avoid a partition deed? That's the whole question, merely because you may have sold the property thereafter.
My lord, they have jointly sold the property.
Yes.
Both the parties in the partition, they have jointly sold the property.
Yes.
The whole property, not
Yes.
out of one of the shares.
Unless the parties make a joint statement in the consolidation proceedings by way of an affidavit, the partition deed cannot be ignored. There must be a voluntary action, again jointly saying the partition deed need not be acted upon.
My lord, both the parties actually had died.
That's all. So you're stuck with that partition deed now. You cannot avoid it unless you get it declared to be illegal.
That is the view of the Honorable Single Judge.
That's right.
Because it is a registered person deed.
Correct.
He is saying that after this registered person deed, both parties have jointly sold the property, which otherwise means that the person deed has not been acted upon. But the view of the Honorable Single Judge is that unless that registered document is set aside or nullified by any competent court of law, that stands.
The challenge in the present appeal is to an order dated 13th February 2015, passed by the learned single judge, dismissing writ petition civil 6172/2003, thereby upholding an order dated an order of the Commissioner Consolidation in Consolidation Division number 2 of 2002, CH and PFL Act. Full stop. Paragraph. By the aforementioned order, the Commissioner Consolidation had set aside an order dated and an order passed by the Deputy Director in appeal case number 19 of 2000, and revived the order of the Consolidation Officer in remand revision petition number 355 1995. Paragraph. One of the questions that arose for consideration before the single judge was whether a partition deed between the brothers, that is late Raja Kalapahad and the late Raja Kalapahad, way back on 21st June 1967, could have been overlooked by the consolidation authorities only because subsequently there were registered seal deeds recording the sale of different portions of the property jointly by the two brothers. Question was answered in the negative by the Consolidation Commissioner and upheld by the learned single judge. The specific observations will learn single judge in this regard is contained in para 7 of the impugned order, which reads as under. Paragraph. Having heard learned counsel for the appellant, the court is not persuaded that any error has been committed by the learned single judge in the commissioner consolidation for the aforementioned reasons. Full stop. There's no merit in the present appeal and it's dismissed as such. All the applications you say in view of the decision in the appeal on merits, these applications do not be required to be dealt with at this stage and they're disposed of.
Item number 12.
None appears dismissed.
Item number 13.
None appears dismissed.
Item number 14.
None appears dismissed.
Item number 15.
None appears dismissed.
Item number 16.
My lord. May it please, ma'am.
Yes, please.
Item 16, my lord, the writ appeal number 488 of 2017, which was in which the present order was assailed, your lordship by the order dated 18 of to dismiss the writ appeal, holding that this is a policy matter of the government. Single judge are rightly dismissed.
My lord, I don't know, because there are two observations in the single judge order, my lord. I am on the first category of cases where, my lord, the upper age limit was 42 in different resolutions, but in 2016, first it was reduced to 35 in 2013, my lord. Thereafter, it was challenged and a high power committee was constituted. After the observation of the high power committee, it was directed that let they be appointed, my lord. And there was a vacancy, lord. For that reason, my lord, in 2016, the government came with a policy that it has to be reduced to 32 years old, my lord. Now, my lord, the question is that whether that resolution is arbitrary or not. My lord, that was the issue that was before honorable single judge.
No, now you are 43.
No, my lord. We are below 42, my lord. We are below 42.
No. Just you're the appellant, right?
My lord.
Just come to the cause title itself.
Yes, my lord. It is 38. I'm 17, my lord.
38 plus 5. We are in 2022, yes, sir. So you're 43.
My lord.
And the others two are even older.
Yes, my lord.
They're all above age.
My lord.
So even if you succeeded, you're overaged.
My lord, can I submit some? My lord, let it be then in that light, my lord, let it be disposed.
That's what. The challenge before the learned single judge was regarding the applicability of the Odisha bracket civil service fixation of upper rules 1989, which had reduced the upper age limit from 42 to 38 years. Full stop. The present appellants were contending that the change was not applicable to them for the posts of engagement, for the purposes of engagement in the posts of Sikya Sahayaks, since such rule was applicable only to the recruitment in civil services or civil posts, pensionable establishments. Stop. In other words, it was being contended by the present that the upper age limit as far as recruitment of Sikya Sahayaks is concerned should remain at 42. Paragraph. From the cause title of the present appeal, it appears that appellants 1, 2, and 3 were, at the time of filing of the writ appeal in 2017, aged 38, 39, and 40 years respectively, which means each of them is now 43, 44, and 45 years respectively. Full stop. Assuming that the appellants had succeeded before, they have in any event crossed the upper age limit of 42 years and are therefore ineligible to be engaged at Sikya Sahayaks anymore. So stop. The appeal has therefore been rendered infructuous and is disposed of as such.
Item number 17.
You are for the Union of India.
Union of India.
None appears dismissed.
Item number 18.
None appears dismissed.
Item number 19.
None appears dismissed.
Item number 20.
None appears dismissed.
Item number 21.
Your Lordship, I'm appearing to video conference.
Yes, please.
I'm appearing on behalf of Mr. Senior Counsel J.R. Dora. The opposite, the respondents have filed counter, but the counter yet not been served. 2 weeks time may be permitted to file a note of argument.
This is a writ appeal, sir. There is no need for rejoinder and all that.
Lordship.
It's a 2018 matter.
Yes, Lordship.
So you please proceed, sir.
Lordship, the counter has not been served, Lordship.
Sorry?
The counter has not been served.
Not necessary, sir. It's a writ appeal.
Your Lordship. Lordship, the matter relates to dismissal of the appellant. The appellant was the senior clerk in Odisha Khadi and Village Industries Board. He was dismissed on the grounds of that he was abusing his official position and tried to embezzle funds with dishonest intention. Regarding which he filed a writ petition number 3133 of 2002, which was dismissed as the Honorable Court disposed of the writ petition with direction to prefer for appeal. The appellant then filed an appeal before the disciplinary board, and the appellate authority rejected the appeal on 19/8/2002, against which the appellant filed writ petition number 5355 of 2005. During the pendency of the said writ petition, please look into para 3 of the appeal. During the pendency of the said writ petition, the management, by resolution dated 10/2/2009, exonerated from all the charges and ordered for reinstatement and directed the appellant to withdraw the writ petition within 15 days. The appellant then withdrew his writ petition by order dated 9/9/2009. But then he was not reinstated, and no financial benefit was given to him. Against that, then the respondents filed a missed case stating that the resolution of the board was not approved by the government, and the missed case was disposed of on 10/2/2009, stating that Mr. was disposed of on 18/12/2009. Look into para 5, Your Lordship. That stating that by the division bench, stating that the government approval was not required. Again, the respondents filed an SLP, and the said SLP was also dismissed, dated 12/3/2010. Then, as the writ petition was already, the main writ petition which was challenged was already withdrawn, the contempt petition was also granted, and the High Court said that the High Court said that the court did not interfere with the contempt, but granted liberty to work out these remedies, for which the appellant filed writ petition number 1757 of 2010. The honorable single judge, without looking into the facts and law of the case, dismissed the writ petition as without merit, and hence this present petition, Your Lordship. Present appeal, Your Lordship. Sorry. He was exonerated of all the charges, Your Lordship.
So detailed reasons have been given by the single judge. Read para 16, page 19 of the paper book.
Yes, Your Lordship. Yes, Your Lordship.
Yes.
Your Lordship, but in the writ petition number 2005, during the writ petition of 5, the board of management resolution 10/2019 exonerated the appellant from all the charges and ordered for reinstatement. Also,
that is an illegal order, sir. It is by the subsequent board. It has not got approval of the government. So the subsequent order dated, resolution dated 10th February 2009 of the board is not valid in the IF law. That's the finding.
Yes, Your Lordship. But then the respondent also filed a miscase regarding the same, but that was upheld. That was dismissed.
No, but that being upheld is not because on merits. That is not on merits, sir. Just come to para 21. The very same argument has been dealt with by the single judge. Come to para 21.
Yes, Your Lordship.
Yes. Please read para 21.
Yes, Your Lordship. This court has taken into consideration the submission to learned counsel.
You can read it loudly.
Yes. This court has also taken into consideration the submission of the learned senior counsel appearing for the petitioner that since the order dated 10/2009 passed by this court has been affirmed by Apex Court, hence it is not to be implemented. But this submission is not sustainable in the eye of law in the view of the fact that the Honorable Apex Court has not examined the factual aspect of merit. Rather, SLP has been dismissed in line. As such, this court in exercise of power conferred under Article 226 Constitution of India to see legality and propriety of this decision of the board dated to 10/2009 before passing the nature. If decision of the board is illegal, the same cannot be directed to implement in exercise of the extraordinary jurisdiction conformed under 26. But Your Lordship, this said is not illegal, sir, Your Lordship. Under Section 32 of Odisha Khadi and Village Board Act, it is permitted, Your Lordship.
Yes, but that has not been affirmed by the government, sir.
Your Lordship, can you look into para 5 of the appeal? Your Lordship.
Yes. Yes.
As per Section 32 of the Act and Regulation 2, Clause I, Clause 4 of the government.
17 also, sir. 17 also.
Yes, Your Lordship. So it states that for any matter of policy, state government's approval is required, Your Lordship.
Yes.
This is not a matter.
There's no power in the board to review an earlier order. The appellate board could not have simply reviewed the earlier decision of 4th January 2005.
Yes, Your Lordship, but kindly look at the para 3 of the writ appeal, where it stated the board in its resolution dated 10/2009 expressed displeasure for wrongly presenting the facts in the early meeting.
No, but there's no such power to review it, sir. That's the single judge.
Yes,
where is the power to review?
So the single bench has
and that too 4 years after the earlier decision.
Your Lordship, the matter was dismissed, Your Lordship, but the respondents are filed, Your Lordship. Once they admitted and then they are filed, Your Lordship. They admitted to reinstate, Your Lordship. It's a matter of concern to Your Lordship. 20 years have passed.
Yes. We're not inclined to interfere, sir. In fact, he was already 63 was filed. We'll pass the detailed order. Dismissed. All right.
Obliged.
Item number 22.
None appears dismissed.
Item number 23. Item number
23.
Item 23.
None appears dismissed.
Item number 24.
None appears dismissed.
Item number 25.
None appears dismissed.
Item number 26.
Lord, item 26. There is a batch of writ appeals
Yes.
pertaining to the petitioner's grievance, appellant's grievance, as to consider them as for their promotion for the year 2009-10 as they are eligible in that year. Though I am
Item
otherwise
26, before my senior starts, in this case, I have been instructed to appear.
Yes.
For respondents, a copy of the writ appeal may be served on me, my lord.
No, in addition to Mr. Khuntia's
Two writ appeals are there. I have also one writ appeal of mine. That is the last case.
I am anxious for early disposal. Khuntia instruction for respondent number 3. One just Mr. Khuntia, kindly.
If a copy will be served on me and it can be taken up next week.
1 second, Mr. Khuntia, 1 second.
Yes.
I'll request to. My problem here is, in addition to the service of copy, there is a respondent number 3 who has been all through trying to avoid notice.
Tarani Sen Bhanch.
Yes, if Mr. Khuntia also appears for respondent number 3,
I can take notice for him.
that's fine, Milord. Next week, Milord, I can.
Mr. Khuntia, learned counsel appearing for opposite parties. Opposite party number 1.
My lord, I am
I am from the private.
Oh, private opposite party number?
3, my lord.
2, 3, and 4.
2 to 4.
2 to 4 states that seeks a copy of the appeal to be served on him. Mr. Ratha states that Mr. Ratha, learned counsel appearing for the appellant, states that he will serve a copy within the next 2 days. This is in writ appeal 294 of 2008.
I am anxious for early disposal. Can it be next week? So that
I am for 304, my lord.
All right.
But I am appearing for in writ appeal number 304 of 2018.
All right, sir. All right.
I do not know whether he requires any copy from me or not. From
Yes.
No, he doesn't spare Mr. Misra also.
So, Mr. Khuntia, you appear for the private opposite parties in all the writ appeals?
Yes, ma'am.
Oh.
Yes.
All right. Copies of the writ appeals should be served on Mr. Khuntia.
By tomorrow, I can do that, man.
All right.
Yes, ma'am. I can also.
By tomorrow. All right. List on 23rd November.
My appearance may kindly be noted for all. Copy number 1. PS Naik.
No, not 23rd. 1 minute. 1 minute.
Lord, that's what I was just trying to pray. If I'm not inconveniencing my lords.
17th November maybe.
That will be that will be fine, man.
17th November.
That's right.
Just call him out. Item 20.
Item number 20. Headmistress Jagabandhu Memorial Girls High School.
Ganesh Chandra Barik.
Microphone as well.
ଅଛି ସେଟା ହଉଛି ଗୋଟେ ଡେଟ୍ କରିବା ପାଇଁ ମୁଁ ଚାହୁଁଥିଲି ଆଉ
Item 25.
ଏ ଫାଇନାଲ ଅର୍ଡର ପାଇଁ ଗୋଟେ
No, there's no order passed so far in this. No order at all. Arrears of current salary to respondents. Why should we interfere in this? No stay. Just asking, why does he want an adjournment? Why does he want an adjournment?
What is the reason for your adjournment? Why are you seeking for adjournment?
No, you are talking. He doesn't speak English.
So, କାହିଁକି adjournment ଚାହୁଁଛନ୍ତି? କ'ଣ କାରଣ କ'ଣ?
ସେମାନେ ତ ଡ୍ୟୁଟି କରୁନଥିଲେ, ୱିଦାଉଟ୍ ଡ୍ୟୁଟିରେ ସେମାନଙ୍କୁ ପଇସା ଦିଆହେଲା, ତେଣୁ କରିକି ଆମେ ସେଇ ଅନୁସାରେ ତାଙ୍କୁ
ଆଜି ସମୟ ନେବେ ନା ଆର୍ଗ୍ୟୁ କରିବେ?
ଆଗେ ସମୟ ନେବି।
ସମୟ ନେବେ?
ଆଜ୍ଞା।
କ'ଣ ପାଇଁ ସମୟ ନେବେ?
ଆମେ ସେ ଓକିଲ ଆସିପାରିଲେନି, ତେଣୁ କରିକି
ଓକିଲ କ'ଣ ପାଇଁ ଆସିପାରିଲେନି?
ସେ କହିଲେ ତ ମୁଁ ଯାଇପାରିବିନି ଆଜି।
ନାଇଁ वकील has filed it.
ନା ଓକିଲ କ'ଣ ପାଇଁ ଆସିପାରୁନାହାନ୍ତି?
ମୁଁ ଜାଣିପାରିଲିନି, ସେମିତି କହିଲେ ଏ କଥା, ତେଣୁ ଆମକୁ
କିଛି କାରଣ ଥିବ ତ, କ'ଣ ପାଇଁ ଆସିପାରିବାନି କାରଣ ଥିବ ତ?
ସେ କହିଲେନି କିଛି ଆମକୁ, କହିଲେ ମୁଁ ଯାଇପାରିବିନି, ତମେ ଯାଇକି ଟିକେ ଗୋଟେ ଇଏ କରିକି ଟାଇମ୍ ଗୋଟେ ନିଅ, ତାପରେ ଆମର ଫାଇନାଲ।
Just tell him we won't simply adjourn. He has to give us a good reason for adjournment. Where is the Sahu who's engaged by the Pradeep Kumar Sahu?
ବିନା କାରଣରେ adjournment ଦିଆ ହେଇପାରିବନି, କିଛି କାରଣ ଦର୍ଶାଇବେ ନା।
ସେ କହିଲେ ଦେହ ଅସୁସ୍ଥ ବୋଲି, ତ ସେ କହିକି ମତେ ଆମକୁ କହିଲେ, ଫୋନ କଲେ।
ବର୍ତ୍ତମାନ ଆପଣ କହୁଛନ୍ତି ଦେହ ଅସୁସ୍ଥ, ସେତେବେଳେ କହିଲେ ନାଇଁ ହଉନି।
ନା ଜାଣି ଆମେ ସେ କହିଲେ ଏ କଥା, କ'ଣ ପାଇଁ ରହିଲେ ମୁଁ ଆମେ କେମିତି ଜାଣିବୁ ସାର୍? ସେ କହିଲେ ଦେହ ଅସୁସ୍ଥ ପାଇଁ ମୁଁ ଯାଇପାରୁନି, ତମେ ଆସିକି ଟିକେ ସାର୍ଙ୍କୁ ଦେଖା କର। ସେଠୁ ସେ ମ୍ୟାଡାମଙ୍କର ପରୀକ୍ଷା ଅଛି, ମ୍ୟାଡାମ ମତେ ପଠେଇଲେ।
ମ୍ୟାଡାମଙ୍କର ପରୀକ୍ଷା ଅଛି?
ଆଜ୍ଞା।
କି ପରୀକ୍ଷା?
FA ପରୀକ୍ଷା ହଉଛି ଏବେ, FA 1 ନା 2 ହଉଛି ପରୀକ୍ଷା।
Respondents' age also may kindly be also be seen.
हेडमिस्ट्रेस जगबंधु मेमोरियल कॉलेज
के हेडमिस्ट्रेस संग परीक्षा चलछि?
आज्ञा मते ऑथराइजेशन देले देख टाइम ना पई।
Where is the lawyer? Appellant is in some difficulty today. List on. February
9 February ଆସିବ।
9 February.
Old matter item number 27.
None appears dismissed.
Item number 28.
None appears dismissed.
Item number 29.
None appears dismissed.
Item number 30.
Milord, am I audible, Milord?
Yes, please.
Yes, Milord. Against the impugned order of the single judge under Annexure 1, the has been prepared. The grounds that the direction has been given for regularization of the employees, those who are continuing pursuant to the by interim order of the court, and kindly have a glance to the short date is that on Annexure 2/1 may kindly have a glance. Annexure 2/1 at page 25, and the relevant page is at page 26. The municipal council wanted to engage 100 employees for a daily wage on the basis of 44 days basis, and that was sent to the government, but the government approved only 94 posts under Annexure 3 at page 29, Milord. And that was given up to a period of 28 to 99. That was, Milord, kindly have a glance at page 29 in the right side column. It is also given in the written in Odia. The purpose is that it is up to a period of 28 to 99. So thereafter the employee petitioners number 1 to 13, they were engaged by the order of the chairman of the municipality who has no jurisdiction. And those appointments are at Annexer 5 Millard, 5 series. All the appointments of 13 employees, DLR employees, starts at page 33. And those appointments are given. It was also in the very appointment it was given that they are posted engaged as tax collector till 28. That means the date that has been approved by the government. So after 28/2/99, there was no continuance of that by order of the government. Government did not further approve that or did not pass any order, but they continued against the impugned order of the chairman giving appointment without following the due procedure of law. Certain councillors, they came up to this court, and that order I have annexed, my lord. Kindly have a glance at Annexer 7 at page 47. At page 47 in the middle paragraph, it is said that in the interim, operation of the order at Annexer 5, that is the appointment order issued by the chairman, and appointments, if any, made on that basis shall remain stayed. And after this, the employees came up. The employees came up in another case, that is at page 48. They obtained the interim order, that is under Annexer 8 at page 48. The interim order was, if the petitioners have been in respect of the posts which have been approved, they shall not be disengaged without leave of this court. And pursuant to that order, they continued, and till 2016, and in 2016, they filed a writ petition that is under Annexer 1, which was disposed of on 14/5/2018. In the middle paragraph, it is there by, may I place it, fourth paragraph. In fourth paragraph, it is, they wrongly submit that by advancing his arguments, thus for the petitioners submitted that the petitioners have already worked for more than 10 years as NMR and DLRs respectively. It is further submitted that their continuance is not by virtue of any interim order passed herein, and the same is pursuant to the development in the year 98, and they are allowed to continue in process of recruitment, so and so, and ultimately directed that they be regularized all the employees appointed prior to 98 in the last paragraph, directed all the employees appointed prior to 98, government be moved, and all. Now, my lord, the problem is that they not only they continued, Umadevi case is a barrier for that, and they continued by virtue of the interim order, and after continuance of such a period, the London single judge, without considering the, my lord, I have set out the grievances grounds at page 12, my lord, kindly have a glance. A, B, C, D, these are 4 grounds I have set up, my lord, kindly have a glance. In ground number A, I have said that the impugned order dated 14/5/18 passed number 12343 of 16 by the Honorable Court is contrary to the interim order dated 24/2/99 passed in OJC number 2648 of 99, for which the same is liable to be set aside. Now, that is at page 48, running page at 48 under Annexer 8, which I have placed before my lord. Now, in ground number B, there is a statutory bar for regularization. That is, for that the impugned order is against the provisions made in section 73A, 73B, C, and D of the Odisha Municipal Act and circular issued by the government time as a matter of policy in respect of regularization of service of the DLR employees, and hence the impugned order is liable to be set aside. These provisions, 73A, 73B, C, D, I have quoted those provisions of law at page 8, my lord. Kindly have a glance. In paragraph 12 of my writ petition, I have quoted the provisions which says that 73, if any such violation is there, there would be any penalty against the authorities. 73B say bar of regular 73 say abatement of claims. 73D says irregular appointments to be voidable. These provisions have not been taken care of by the Honorable Single Judge, and that is why the ground number B has been set out. My Lord, kindly have a glance to the ground number C. That is there. The state government has imposed a ban after 12/4/93 being outcome of the illegal exercise of the power. The chairman of Baleswar municipality, without following general principle of law, following advertisement and principles made under the ORB Act being illegal, it cannot bring a right up for the writ petitioners for their regularization of service, and thus the direction given by the Honorable Single Judge is liable to be set aside. And the last ground I have taken, my Lord, in the Umadevi case, for that the law is well laid down in case of Umadevi and others, and in view of present facts of the case, it will cause serious prejudice to regularize all the 45 numbers of employees without any sanctioned post, and hence the impugned order is liable to be set aside. Now, my Lord, these 13 petitioners, they are out of these 45 numbers. And there is a factual mistake that though municipal council wanted to engage 109 employees, but the government has sanctioned only 94, out of which 88 employees have already been appointed. So there remains only 6 posts vacant by then. Now in these changed circumstances, and there are 45 still awaiting persons, they cannot be regularized without the interference of the government and without the sanction of the government, and in violation of the statutory provisions of 73A, 73B, 70C, and D. Without looking into all these facts, and without the petitioners should have brought to the notice that they are continuing pursuant to the interim order passed by this Honorable Court under Annexure 8. Later on that Annexure 8, the writ petition stood dismissed for default, for non-prosecution. Both the cases that challenging the appointment issued by the chairman through some councillors, that was also dismissed on Annexure 7 interim order. That stood dismissed on 7/12/15, and the Annexure 8 continuance order without leave of the court, they cannot be termed out. That was also dismissed on 2/5/18, and that I have also given the statement at paragraph 11 at page 8 of the writ petition below. My Lord, the whole contention is that does not bring a right for them to be regularized in view of the Umadevi case and in view of the facts that I have submitted, and because the non-submission of or saying that there were 109 posts approved, it is not at all correct. Rather the Annexure 3, on the basis of which the Single Judge has said, the entire Annexure 3 will show there are 22 categories of employees and total number of posts are 94, not 109. So there cannot be the impugned order shows that there are 30 vacancies still pending is totally incorrect. That is why I have just drawn my Lord's kind attention, though they are employees and working since long. But the law must be there, or it must be clarified whether 73A, B, C, D of Municipal Act, what to take care of, or without order of the specific order of the government or the court, it cannot be.
May I submit my law?
Yes, yes.
I am for opposite party number 1 to 13 in the
Correct.
Whatever my learned friend Mr. Panda submitted, not a single point was addressed before the Honorable Single Judge. Your Lordship will find from the counters, also from the order passed by the Honorable Single Judge, it is rather an agreed order. Your Lordship, for a moment, Your Lordship may kindly come to the counter file in the writ application.
Right.
May I read only 2-3 lines?
Yes.
That is available in inner page 6, running page 38 of the brief, my lord. The letter under Annexure 2 was placed before the Municipal Council in its meeting dated so. Thereafter, the matter was placed before the Municipal Council in its meeting dated 7/3/19, and the resolution under Annexure 3 was passed, wherein it was resolved that if the DLR or NMR employees would be terminated, it would cause a lot of inconvenience to the inhabitants of the municipality. Therefore, it was decided to accord 44 days appointment to the said DLR employees with an artificial break of 1 day. While the matter stood thus, the Municipal Council in its meeting dated so passed a resolution under Annexure 4 to the effect that the DLR employees who are appointed within the prescribed yardstick under Annexure 3 series, their services would be regularized and the government would be moved to accord creation of posts so as to permanently absorb the DLR employees. And now, my lord, after 4 or 5 sentences, as a consequence of the letter under Annexure 5, 88 persons who were working on DLR basis, their services were regularized. Similarly, in the next page, inner page 88, my lord, the municipality could not close its eyes to the need of the municipality and also to the pitiable condition of the DLR employees. Basing on these submissions only, Honorable Single Judge passed the order. Your Lordship may kindly come to the order passed by the Honorable Single Judge. There also, the Honorable Single Judge has taken note of those things. Inner page, my lord, 19 of the writ appeal. 19 of the writ appeal. Your Lordship may kindly allow me to submit that. Baleswar municipality has not taken any step to regularize the petitioner who are all continuing with an uncertainty in their career even after working sincerely over several decades. It is in the above premises, it appears the municipality is already taking, I am giving emphasis on this, my lord, the municipality is already taking steps for regularizing the persons of the particular category and for the posts having been created by the competent authority. The petitioners claimed that there is no justification in holding up the regulation of the petitioner and against the vacant post. Next para, it is at this stage the matter land counsel for the opposite part number 3 and 4, Mr. Panda IAPN Mohoday, referring to the counter affidavit and drawing attention of this court to the notice submitted that the regularization of the petitioners are awaited pending direction of the state government. Sri K.K. Mishra learned additional government advocate in response to the allegation and the prayer made by the petitioner referring to the counter affidavit filed by the office part number 1 to the petition filed on 17/4/98 as referred to herein submitted that government is taking steps to create posts for regularization of the particular AMRs in the Valsad municipality. So, basing on the submission of the state councils, also Mr. Panda appearing for office part number 3 and 4 for Valsad municipality, the Honorable Single Judge passed the order. Last paragraph, my lord. Considering the rival contentions of the parties and taking into account developments from time to time, taken particularly keeping in view the development through paragraph 3 of the writ petition that the government sanctioned about 109 number of posts for regularizing NMR DLR working in Baleswar municipality by letter of so. And as this
are there so many posts?
Sorry, my lord.
One of the so many posts are simply not available.
109. My lord, Mr. Ponda was saying about number of posts under 9 year lordship may kindly come to Annexure 1 in the writ petition. It is very
94. 109 was said by the council, but government approved only 94 posts.
That's what I don't dispute.
That's what I'm saying. That's what I'm.
No, the 109 figure is totally incorrect.
That is not the point of dispute. That is not the point of dispute. Honorable Single Judge has not said about that thing against that 109 posts.
Honorable Single Judge is saying that there are 109 vacancies. It's not that.
Possibly, my lord. Possibly,
the basis itself shows there are 22 categories of 94 posts, out of which 88 employees were there. Only 6 posts were left vacant by then.
Possibly, my land friend is missing the directive portion of the.
That appointment was only up to a period of 28/2/99, not thereafter. Thereafter, government did not approve the same for continuance of their engagement. They continued their engagement only because of the order passed by the.
May I draw your lordship's attention to the last paragraph of that order, where the directive portion is there. Last 4 or 5 lines in page 20, my lord. The chairman Baleswar municipality is directed to make immediate correspondence to the government of Odisha for creation of post to regularize the balance of NMR and DLR employees. This is rather an agreed order because of submissions made by the opposite party 3 and 4, Mr. Panda appearing for the Balsam municipality, so also state council. Government is taking steps.
No, but factually, sir, there must be posts. There are no such posts.
That is not the what is the direction? If I am not wrong, my lord, the direction of the honorable single judge is to move the government for creation of post. Creation of post. Language is creation of post. Language is your lordship. I'm sorry, my lord. I am dragging your lordship once again to that, inviting your lordship's attention to once again to that sentence. The chairman, Balsam municipality director make immediate correspondence to the government of Odisha for creation of post.
I know, but is that beyond the scope of the writ petition?
Yes.
The writ appeal, my lord, on the last occasion or the last date of hearing before another division bench, I raised a question. Preliminary objection, my learned friend Mr. Ponda is not answering to that. In a writ appeal, can a new point be taken? All the points taken by him in the appeal are totally new points. No, those were not in the counter in the writ petition.
No, but factually, it is not a new point. Factually, if there are no 109 posts, then how do you give a direction for creation of posts? How do you give a direction? What happens to seniority? What happens to people who are already there?
Already, nobody there.
No. Please, there are 45 DLRs. There are 45 DLRs who are already working, sir.
They have already been regularized. Let my learned friend Mr. Ponda dispute that, my lord. Nobody is there for regulation. We only about
come to para 15 of the writ appeal. Please come to para 15 of the writ appeal.
That's what I'm saying, my lord. These things were not addressed before the honorable single judge.
No, but this is factual, sir. There's no question of a new ground. Just come to of the writ appeal, page 11.
In that event, if your lordship permits me 2-3 days, and 2018 this writ appeal was filed. That time this factual position was this. Today, my lord, it has undergone a sea change. That's what my instruction from my clients, that only 50, these are 13 in numbers, another 2-3 persons, 16-17 persons are left behind. Others have already been.
What is the age of some of your clients?
Age, my lord, I can see from the writ petition.
One of them has already retired, my lord. That is yesterday.
Possibly in the meantime, some I don't dispute that.
All right. The counsel for the respondents 1 to 13 seeks time to obtain instructions on the current status of vacancies.
Yes, ma'am.
In the post of DLRs, and also indicate which of the respondents 1 to 13 are still in service, awaiting regularization.
My lord. Your lordship.
Affidavit be filed at least 1 week prior to the next day, to counsel for the appellant. Interim order to continue. List on. First February.
Obliged.
Item number 31.
May I please, Your Lordship? The Lord Single Judge has rejected the writ petition only on the ground that I have not explained the delay of 1 year, 7 months.
Yes.
In preferring the writ petition. Though I explained in the delay, Your Lordship can see first paragraph of my writ petition, I have quoted that. Your Lordship can see paragraph 12 and 11 of the writ petition I have quoted because at the time of revision, my lord, I had engaged a lawyer who did not appear before the court and even did not inform me that the order has been passed ex parte. And when I came to when my property was going to be recorded in the name of the government on the basis of that order, I came to Cuttack and know that such an order has been passed. Thereafter, I challenged that order by filing the writ petition. Your Lordship can see the impugned order. I have narrated, I have explained the delay in paragraph 11 and 12. I have quoted that. At paragraph 1 of my writ petition, by writ appeal. Let the delay I have explained this thus, my lord. The petitioner on receipt of the notice in both cases engaged and trusted his advocate to defend him in both the revision cases. But unfortunately, the advocate who was engaged on behalf of the petitioner did not appear. case date of hearing, and both the revisions were heard ex parte on the date fixed for hearing. Though the impugned order was passed by the commissioner on dated 3/6/2015, the advocate who was engaged in the case did not even inform the petitioner that the case has been disposed of.
But why did you not contact?
Miller?
Why did you not contact your counsel?
You
filed the revision case in 2013.
Yes, Miller.
Till November 2016.
2016, I had contacted, but he has given the info. Miller, if he has not informed me that such and such that the case has been posted, or you come. When the date was fixed, it was not within my knowledge. And nothing was informed to me. In these circumstances, in these unfortunate circumstances, my Lord, I have a good case, your Lords. You can see the property was recorded as Bajapti Sthitivan on the merit, your Lords. You can see. Thereafter, this was leased out to me, and it was also Tahsildar passed the order recognizing me as the and I have paid the rent to the government. And during the consultation operation also.
July 2018, passed by the learned single judge, dismissing writ petition civil 9860 of 2018 filed by the appellant, challenging an order dated 22nd November 2018, passed by the learned commissioner, Land Record and Settlement, Odisha, in consolidation revision case number 30 of 2013. Full stop. Paragraph. The sole ground on which the writ petition was dismissed was that the impugned order had been passed on 22nd November 2016, and yet the writ petition was filed only on 8th June 2018. Full stop. The learned single judge was not convinced with the explanation offered by the appellant for the delay of 1 year and 7 months in filing the writ petition. Paragraph. In the present writ appeal, despite service of the respondents, none appears on their behalf. Paragraph. In the writ petition before the learned single judge, reasons were adduced for the delay in filing the writ petition in para 12. Full stop. Those reasons have been reiterated in ground A of the writ appeal that did not inform the appellant about the dismissal of the case. And it is only when the appellant visited Cuttack in May 2018, he was able to learn that the impugned order was passed on 3rd June 2015. Paragraph. It does appear to the court that in the present case, the explanation offered by the appellant is not lacking in bona fides. Full stop. It appears to be a genuine reason. And the appellant should not be deprived of pursuing the remedy of challenging the order in revision only because of the lapse of his counsel. Full stop. For the aforementioned reasons, the impugned order 18 of the learned single judge is set aside, and writ petition civil 9860 of 2018 is restored to the file of the roster bench of the learned single judge, where it will be listed for hearing on 6th December 2022, on which date the present appellant will appear through counsel. The learned single judge is requested thereafter to proceed with the writ petition on merits and endeavor to dispose it off as expeditiously as possible. The writ appeal is this. Until the disposal of the writ petition, the interim order passed by the court, by this court, in the present writ appeal will continue. Would like.
Item number 32.
None appeals dismissed.
Item number 33.
Yes, dismissed.
Item number 34.
But please, minutes.
Yes.
Order of the honorable single judge is under challenge minutes.
Yes.
There is a rule 289 that I have annexed, my lords, to the writ appeal, annexure 1. Rule 289 says the existing 89(1), the existing employees who have not already exercised their option under the statute shall exercise either for the pension scheme or the contributory provident fund scheme under 288, statute 288, within a period of 6 months from the date on which these statutes come into force. This statute has been enacted, this is under the first statute, which has been enacted under section 3 of the Orissa Universities Act, my lords. And this is a statutory provision, my lords. And provided, then 2, my lords. The option as provided above shall be exercisable only one aspect of either scheme, that is either contributory provident fund scheme or the pension scheme, my lords. Irrespective, and shall be final, irrespective of any change that will be made in such scheme from time to time. The fact of exercising such option shall be recorded in the service book of the employee by the registrar or such other officer nominated by him. If any employee fails to exercise the option required under these statutes within the prescribed time limit,
so this person wants to be governed by the
he has already exercised his option under the rule says that if you fail to exercise the it shall you are automatically you will be considered under the pension scheme. New scheme. And you are to be exercised the option only once. And that is within 6 months. As a special case in this case, twice that option was given. This person has already exercised his option. He says, I am to be governed by the contributory provident fund scheme. His name finds place, your lordship will see, in page 20, item serial number 50. Before that, in annex, pursuant to this office notification number so and so, the following teachers of PG department have opted for contributory provident fund scheme. Now, this gentleman has exercised his option. Next page, serial number 50, Sarath Kumar Acharya. So he has already exercised his option way back in 1989, pursuant to the scheme. Now, after that, he comes in 2011 and he says that I have found out later. In retrospect, I found out that there are additional benefits under go back to the pension scheme. The Honorable Single Judge allows his prayer on the ground that paragraph 4. Today, the learned counsel for the petitioner, citing the notification dated 21/7/2017 issued by the Ministry of Human Resource Development, which has been published in the Gazette of India Extraordinary. He relying on this Gazette notification, my lord, the Honorable Single Judge allows. Now, this Gazette notification, my lord, your lordship will see that that's part of the single judges. This is for not at all meant for the institutes like the present petitioners. I'll just place that first part. In exercise of powers conferred under subsection 1 of Section 26 of the National Institutes of Technology Act 2007, the central government, with the prior approval of the visitor, frames the following first statutes for all national institutes of technology. So this notification is applicable for the NITs under the NIT Act, but the present Sambalpur University is covered under the Orissa Universities Act, my lords. This is this statute. The statute, relevant statute is the Orissa Universities Act 1989, and the first statute is 1990 is framed under the Odisha, my lord, under the provisions of the powers conferred under subsection 3 of section 24 of the Odisha Universities Act 1989. So we are covered, the Sambalpur University is covered under this, my lords. So by no stretch of imagination, the other regulation have applied to this. So under a mistaken notion, my lords, is on the face of it. The Honorable Single Judge allows his prayer. And that too at a extremely belated date, just prior to his retirement.
All right.
Whereas he has already exercised the option long back, that's in 1990.
All right. You say the challenge in the present appeal is to an order dated 16th May 2018 passed by the London Single Judge, allowing repetition civil 11768 of 2016, filed by respondent 1, and directing that he would be governed, notwithstanding the exercise of an option by him, contrary thereto, by the new pension scheme. So thereby the London Single Judge quashed the order letter dated 25th April 2016, whereby the appellant university, whereby an intimation was sent to the registrar, Sambalpur University,
He opts for he has already opted for the contributory provident fund scheme.
Correct.
He now wants that in the penultimate years of his service.
New pension scheme.
Which is not, that he is not permanent.
Correct. No. Which had barred the change of option after a stipulated period. Full stop. Paragraph. The background facts are that the respondent number 1 was initially appointed as a lecturer in the Sambalpur University on 26th October 1983. Full stop. He became a professor sometime in 1999. Full stop. Sambalpur University is governed by the Orissa University's first statutes, 1990, bracket, the 1990 statutes, bracket, with effect from 1st January 1990. Full stop. In terms of statute 289 thereof, an employee of the university was to be provided with an option to choose either between the pension scheme of the state government or the contributory provident fund scheme, bracket CPF, of the university. Stop. Statute 289 reads as under, take from page 4 of the writ appeal up to page 6, up to end of page 5, sorry, paragraph. This exercise of option had to be within a period of 6 months from the date of coming into force of the 1990 statutes. Full stop. Under statute 289(3), if an employee fails to exercise the option, he/she shall be deemed to have opted for the General Pension Scheme (GPS). Full stop. Paragraph. As far as respondent number 1 is concerned, he opted for the CPF. Full stop. Reference is made to an office order dated 30th October 1990, setting out the names of persons who had opted for the CPF, and the name of respondent number 1 figures at serial number 45 of the said list.
50.
No, you say 45?
No, 40. Yes, 90, 45. In 90, it is 45.
45, yeah. Paragraph. Paragraph. Since since a number of persons had missed the deadline, a recommendation was made for extending the time for change from CPF to GPS, and accepting such recommendation, the government of Orissa allowed a last chance to change the option from CPF to GPS within a period of 1 month from the date of issuance of a letter dated 22nd August 1997. We'll stop. However, this deadline was missed by the respondent 1. We'll stop. A few years prior to his retirement, he submitted a representation on 16th September 2011 to the registrar of the appellant, seeking to switch over to the GPS from the earlier opted CPF. We'll stop. Paragraph. Respondent 1 filed writ petition civil 19708 of 2015, praying that he be allowed to change over from CPF to GPS in accordance with statute 289(3) of the 1990 statutes. Stop. The said writ petition was disposed of on 20th November 2015 with a direction to the appellate consider the representation of respondent 1 in light of the syndicate's recommendation dated 19th September 2011. Paragraph. The representation of respondent 1 was disposed of on 25th April 2016 and rejected since :1 choosing of an option either under CPF or GPS had to be exercised only once in terms of statute 289 of the 1990 statutes. 2. The government of Orissa barred change from CPF to GPS after the stipulated period, and 3. The resolution dated 19 September 2011 of the syndicate was beyond the scope of the statutes. Paragraph. For the second time, respondent 1 filed writ petition civil 11768 of 2016, challenging the rejection of his representation. Full stop. In the said writ petition by the appellant, pointing out the statutory impediments in allowing the prayer of the respondent 1. This writ petition was disposed of by an order dated 16th May 2018, quashing the letter dated 25th April 2016 and directing the present appellants to deal with the case of the respondent number 1 in accordance with the latest notification issued by the Ministry of Human Resources Development, bracket MHRD, open quotation, without any sort of insistence of his option already exercised by him. The said exercise was directed to be completed within a period of 3 months. Full stop. Agreed by the impugned order of a single judge, the present appeal has been filed. Paragraph. While directing notice to issue the appeal on 1st May 2019, this court stayed the operation of the impugned judgment of the learned single judge. Paragraph. This court has heard the submissions of Mr. Subir Palit, senior counsel appearing for the appellant. Despite respondent number 1 being earlier represented by a counsel, today none appears on his behalf. Paragraph. It is seen from the impugned order of the learned single judge that counsel for respondent number 1 had referred to a notification dated 21st July 2017 issued by the MHRD, in terms of which employees of open quotation, the institute appointed prior to 1/1/2004 will be governed by, unquote, the pension rules, and those appointed on or after 1st January 2004 will be governed by the new pension scheme of the central government. It was prayed that in view of the said notification, respondent number 1 should be allowed to switch over to the CPF, switch over to the new pension scheme, right?
New pensions.
New pension scheme. Paragraph. The learned single judge simply observed open quotation. Since the latest gazette notification has come, that will govern the petitioner. So accordingly, a direction was issued to permit the petitioner to switch over to the pension scheme with open quotation without any sort of insistence of his option already exercised by him, unquote. Court notification dated 21st July 2017. Which page is it? Sorry? The 21st July, the writ petition, right?
Yeah, it's in the writ petition, my lord.
How?
It was filed in court also in the date of hearing.
Which page?
Page is 187 possibly.
Of the writ petition?
Possibly, my lords, 187 probably. File.
Yeah, I think it's annexed.
It's
annexed. It's annexed to an affidavit filed on behalf of the petition. That notification was issued under section 26 bracket 3 and bracket 4 of the National Institutes of Technology, Science, Education and Research Act 2007, bracket 2007 Act, with the prior approval of the visitor. Full stop. It had published the first statutes of the NITs. Bracket amendment statutes of 2017. Full stop. paragraph, the learned single judge perhaps failed to appreciate that the said notification was specific to the NITs and were not intended and in fact did not apply to universities like the present appellant. Full stop. Therefore, it was for relief to be granted to respondent 1 in terms of accepting his prayer for switching over to the pension scheme contrary to the option already exercised by him, on the basis of a notification which did not apply to respondent 1 at all. So on that short ground, the impugned order of the learned single judge cannot be sustained in law. Full stop. In other words, the appellant was right in issuing the letter dated 25th April 2016, declining to permit the respondent 1 to switch his option, particularly since he had also already exercised his option and there was no occasion to permit a further option. Full stop. The impugned order of the learned single judge is accordingly set aside. The writ appeal is allowed, but in the circumstances, no order is to us.
May I please, Your Lordship? Your Lordship, I am appearing on behalf of Mr. P.K. Padi.
Yes, please.
Yes, Your Lordship. Your Lordship, in this case, Your Lordship, the appellant has challenged the judgment dated 13/7/2018, Your Lordship. The petition was dismissed by the this honorable court, Your Lordship, by stating that it is not maintainable since the Red Cross Society is not state under Article 12, Your Lordship.
Right.
But Your Lordship, certain facts, Your Lordship, may kindly come to page number 26 of the judgment, Your Lordships. Paragraph 13. May I read, Your Lordship?
Yes.
It has been stated by the learned counsel for the petitioner and has been 8/2/2010 passed by this honorable court. There is a direction to pay current salary from the month of January 2010 till disposal of the writ petition, and due to non-compliance of the aforesaid order, contempt petition bearing CUNTC number 2289 of 2012 has been filed, wherein a show cause has been filed, in which stand has been taken that salary as per the admissibility has been paid out. But learned counsel for the petitioner has taken a stand that the DHRA has not been paid. Your Lordship, the opposite parties were not paying the salary, but when the petitioner approached this court, Your Lordship, and on the direction of the court, the salaries were paid, Your Lordship. Now, so thereafter the contempt was filed, but since it was a fresh cause of action, a fresh writ was filed for the DA and HRA, Your Lordship, but that writ was not entertained, Your Lordship. That is the limited prayer of the petitioner.
No, not entertained by which order?
Your Lordship, order dated 18/7/2018, Your Lordship.
Where is that?
Annexure 1, Your Lordships. 13/7/2018, Your Lordship, sorry. 13/7/2018. It starts from page 10, Your Lordship. Page 10 of the appeal.
1 minute. No, it only says contempt petition is dismissed. Come to page 26.
Yes, Your Lordship. Lordship.
No.
Lordship,
What about the writ petition itself?
Your Lordship, that was withdrawn. That was withdrawn.
The writ petition is withdrawn.
Yes, with the liberty to pursue the representation which was filed before the learned governor, Your Lordship. So that was withdrawn. And after I have made a representation, subsequently an order was also issued by the governor, Your Lordship. Your Lordship may kindly come to Annexure 6 of this petition, Your Lordship. Page number 17.
No, on maintainability is dismissed, sir. It's not withdrawn.
No, there were two petitions, Your Lordship.
No, we are talking of the impugned order.
Yes, impugned order was dismissed on the grounds of Your Lordship.
No, I'm only asking about the impugned order. I'm not asking about your first. In the impugned order, it was dismissed on the ground of maintainability.
Yes, Your Lordship. Yes, Your Lordship.
So what is wrong with it? Your letter of the minutes of the meeting dated 25th November 2004
Lordship.
intended to give report only on a consolidated pay of 5,000 per month.
Yes, Your Lordship, but there was
And there's no question of HRA, DA and all that. The original terms of your appointment.
Your Lordship, may kindly come to page 12 of the writ petition under Annexure 3, Your Lordship. There was clause for the HRA and other things, Your Lordship. Clause 2.2 of the agreement.
No, that is what the learned single judge is pointing out. How can that agreement be contrary to the decision taken on 25th November 2004?
Let they decide on my representation, Your Lordship. Then let I may be permitted to file a fresh representation and it.
No. How many representations? No. There's no question of that. A short point before the learned single judge in writ petition civil. 969 of 2010 and contempt case number 2289 of 2012 was whether the Red Cross Baleshwar branch was obliged to pay the appellate HRA and DA increment and apart from the salary. Full stop. The appellant had placed reliance on clauses 2.1 and 2.2 of the agreement dated 2nd April 2005. Which had envisaged payment of the above additional allowances, increments and other criteria applicable to employees of the state government. Full stop. However, the response of the society, Red Cross Society, was that the appellant had been appointed in terms of an advertisement dated 20th December 2004, which in turn was on the basis of a proceeding held on 25th November 2004. It had been decided by the society that in its district Red Cross branches, only a monthly honorarium bracket consolidated bracket to the extent of rupees 5,000 would be payable. Full stop. For this, the Orissa state branch was to subsidize up to its share of rupees 3,500, and the district Red Cross branch would contribute rupees 1,500 till the end of the project in 2007. Paragraph. It is in the above circumstances the learned single judge observed that the payment terms would be governed by the resolution dated by the minutes of the meeting dated 25th November 2004. And not in terms of the above clauses of the agreement. As a result, even the contempt petition was dismissed. Paragraph. Having heard learned counsel of the appellant, the court is of the view that the learned single judge has not committed any error in rejecting the writ petition. Indeed, the minutes of the society held on 25th November 2004 makes reference only to a monthly honorarium, which is a consolidated sum without any reference to additional allowances like the HRA, DA, etc. Full stop. It was on the above basis that the respondent number 1 was issued the appointment letter dated 31st March 2005. merely because the appointment letter dated 31st March 2005 makes a reference to other allowances would not make the respondent one entitled to those other allowances over and above the honorarium of rupees 5,000 per month. Paragraph. The courts are therefore unable to find any error having been committed by the learned single judge. The appeal is dismissed, no orders is to cause. They've already taken too long orders. Can ask them call.
Item number 36. Item number 36.
None appeals dismissed.
Item number 37.
None appeals dismissed.
Item number 38.
None appeals dismissed.
Item number 39.
None appeals dismissed.
Place admission item number 40.
None appeals dismissed.
Item 41.
None appeals dismissed.
Place admission item number 42.
No, I have to take instruction.
Sorry?
43, I have to take instruction.
Item 42.
42, sir. We are in 42. Pass over.
Item number 43.
May I please, madam? I have challenged the order passed under section 148A(d) that the initiation is time barred, my lord. The assessment year is 2016 and 17, and the notice issued on 30th June 2021. And after the judgment of the Honorable Apex Court in Union of India versus Ashish Agrawal, the Finance Act 2021 will be applicable to the, and after the amendment, the section 149 provides that if the amount is below 50 lakhs, only 3 years is it limitation to reopen the assessment. My lord, kindly have grants to the page 11.
All right. Notice, Mr. Chimanka accepts notice and seeks time for instructions. At his request, list on 15 December 2022 till the next date, no coercive steps.
Item number 44.
Same, I have to take instruction.
My lords, this is not his case. This is Tushar Satpathy. If he wants to appear, let him appear.
He will not appear. Today, Tushar Satpathy will not appear. I will
Okay. Sorry, I didn't know about the arrangement. Let me place the facts.
No, but he's agreeing to take instructions.
Very good, my lords. That will shorten, and I'll have a cup of tea in the lunchtime. My lords, may I pray that the annexer 3 at page 30, at page 20, and the demand notice pursuant to the order of the commissioner
Shall remain stayed. All right.
Stayed.
All right.
15 December.
The initiation itself is barred by limitation.
Right. You say notice, Mr. Chimanka accepts notice and seeks time for instructions. At his request, list on 19 December 2022 till the next date, the impugned order of assessment bracket annexure 3 and the consequential demand shall remain stayed.
Obliged, ma'am.
Item number 45.
May I please the lordships? Lordships, I may be pardoned to appear through history, lordships.
Yes.
The lordships, in this matter, actually, in the last occasion, your lordships has been pleased to pass an order inadvertently. After hearing me, the order has been passed. But my learned friend will also agree with me. I was never heard before the passing of order, your lordship. But in fact, I have filed today an additional affidavit that on 27/10/2022, only I came to know about the impugned order basing on which the attachment has been made, Your Lordships.
No, no. Last time I remember you are appearing.
Yes, I was there. But that opportunity was given to me after filing of this writ petition, Your Lordships. Not for that. Yes,
Your Lordship, on the last occasion, Your Lordship was directed to take instruction.
Right.
Whether
But it was not uploaded. She was saying that I'm not able to find the order.
Exactly, Your Lordship. Your Lordship, I may be permitted to submit, Your Lordship. My clerk is there, Your Lordship. My clerk may, Your Lordship, provide Your Lordship to the copy. Your Lordship, everything has been uploaded. Your Lordship, the order.
So you can, Miss Roy Chaudhary, you can appeal now.
Now I can appeal, but the thing remains, Lordship, that it is now time bad. It will, Lordship, yes, Lordship.
You say it is now confirmed that the order has been uploaded on the portal. Full stop. In that view of the matter, it is directed that the appellant is permitted to, the petitioner is permitted to withdraw the present petition with liberty to challenge the adjudication order by way of a statutory appeal. Stop. If such appeal is filed not later than
within 2 days, Your Lordship, I will file the appeal because my attachment is there.
Right. Not later than 2nd November. Or 3rd November?
Yes, Lordship.
3rd November 2022, accompanied by an application for coordination of delay. Then, and an explanation is offered for the delay on account of pendency of the present petition. Then it will be considered in accordance with law by the appellate authority. Stop. The court clarifies it has not expressed any view in the matter. The writ petition is disposed of as withdrawn for of terms.
Right.
Your Lordship, may clarify one thing, Your Lordship. Why I'm saying so, Your Lordship? Because it is, the appeal is to be filed within a period of 3 months. The limitation, why I'm praying, Your Lordship, because this order may not be, Your Lordship, ratio, Your Lordship. Why, Your Lordship? Here, 107, section 107 says that the appeal is to be filed within a period of 3 months. And here, the first appellate authority can condone the delay for another 1 month. Your Lordship, thereby, there is an outer limit of the for condoning the delay. Your Lordship, as the statute under Central Excise Service Tax, Your Lordship, as that.
So we have not expressed any view in the matter. Let us see what explanation she offers, and the appellate authority will consider it in accordance with law. That's what we have said.
Yes,
We have not said that you have to condone it or anything like that. We only said you will consider it in accordance with law. Right.
I may be pardoned, Your Lordship. My additional affidavit may be taken on record.
All right. Right in the beginning, you said the additional affidavit filed by the is taken. All right.
Oh, bless.
For order item number 46.
None appears dismissed.
Item number 47.
Yeah, none appears dismissed.
47, I am for the opposite party now.
All right.
The NTPs.
All right.
Item number 48.
None appears dismissed.
Item number 49.
None appears dismissed.
Item number 50.
None appears dismissed.
51.
None appears dismissed.
Item number 52.
None appears dismissed.
Item number 53.
None appears dismissed.
Item number 54.
Yes, my lord. I'm prayer, my lord. I'm 80% disabled, my lord. I'm not collecting the proper document. And serial number 4 and serial number 10 advocates already been expired. So that 1 month time may kindly be granted. And remove the defect. I'm audible, my lord.
Yes, yes. What remains in the matter, sir? It's a 2000 writ petition of 2000. What is the matter about?
the matter was dismissed on default.
No, no. What was the petition about, sir?
Petition for promotion.
Sir, what is the age of the petitioner now?
74.
So where's the question of promotion now?
Promotion previously, but fine.
Sorry, sir. We're not going to entertain this kind of a thing.
Yes, my lord, kindly.
Time.
1 month time may kindly be granted.
I could have the file.
This application for restoration of a writ petition, which was dismissed way back on 7th March 2011, has been pending in this court for 11 years now. And defects have not. Counsel for the applicant wants more time to cure the defects, considering the long pendency of the present appeal for over 11 years. The court is not inclined to grant such indulgence. The application is accordingly dismissed. Yes.
Item number 55.
Infractious, my lords.
Infractious is dismissed.
Item number 56.
My lord, this is the same review application your lordship has already dismissed.
Yeah, dismissed.
On merit.
Yeah, no grounds made out for review. The review petitions.
Item number 57.
None appears dismissed.
Item number 58.
No grounds made out for review.
My lord, this is a different type.
Okay. Now then you argue about delay. What's the delay?
Delay is not, I think, section of time.
Okay, 28 days.
28.
Delay is controlled. All right.
This is the the division bench of this honorable court has allowed an application filed against the order of the ADM rejecting the lease 7A of the OJLS Act on the ground that it is beyond 14 years. The application was made. That your lordship has dealt several times, and recently in case of Asahans versus State of Orissa, lordship has said this limitation will not come on the way on the ground that there is fraud played. And in the review application, we have mentioned how the fraud has been played by the lessee by getting the lease in his favor. And that.
Are you sure that's the case? Because it seems to be reading something else. Just see the writ petition. It's about declare Orissa Cooperative Societies Act as ultra virus.
Sorry, my lord, 56 was what I was saying. 58 this order, 56. I'm just pressing 56. Now 58 that order may be passed.
Okay.
I'm very sorry because.
Don't made out for review. 58 is dismissed. 56. All right. 56 will come to it.
So that order.
Here, what is the delay now?
Yes, delay.
165 days.
165 days. We'll put it on that, sir. There's a delay of 165 days in filing the review petition, which has not been satisfactorily explained. Consequently, while leaving the question of law arising from the impugned order open for decision in some other appropriate case, the review petition is dismissed on the ground of delay. All right.
Item number 59.
None appears dismissed.
Item 2.
Contempt case.
Lordship, I want one pass away, Lordship.
No, anyway, we'll have to go before the roster bench, I think. This contempt case, you say, list before the roster bench. And then this 485, none appears dismissed. List before the roster bench on 5th December. All right.
Item number 60.
None dismissed.
Item 61.
None appears dismissed.
No, my lord, I'm there in the virtual mode.
All right. All right.
This is a review petition.
What's the delay?
Delay is only 60. It is due to my illness. I could not able to file.
All right. Delay is condoned. All right. 23 days. All right. Delay is condoned. Yes.
So this is a dispute related to the entry tax matter. Originally, I have challenged the assessment number in 5101 of 2012, and this is regarding that imported matter, entry tax that was settled in the Honorable High Court, Supreme Court, my lord. So that part is I am not One of the dispute is that I have purchased the material in the local area from a registered dealer. So that deduction has not given, and that has not been considered while passing the order. So kindly have a glance to the order, that is page 20, Annexure 1. That is the case of Tata. Originally, it's Tata Steel Limited case. I am the one of the party in that case. So I have purchased the material from Adani Enterprises. This is a registered dealer. So in the question, there is paragraph 9 in page 20.
Yes.
That question has not been framed. That has been not considered. So all the party went to the Supreme Court, but I have not went to the Supreme Court. I have accepted that with regard to the important matter. And this local area already has been covered by our own High Court judgment subsequently. I have given a copy of the to the court master. That is in Snow White Trading Corporation Limited, 71 VST 2014-351. So material purchased within the local area from a registered dealer, that to be deducted from the turnover. The state kindly have a glance to page 4. That question, page 4 of the
question 2.
No,
question 1 and 2.
1, 2, and 3 also.
All right.
That has been answered at page 6.
No, it's all right. So similar questions arise in the present petition, according to you.
My lord.
What do you say, Mr. Mishra?
Your Lordship, in the meantime, the question which has been answered with this order, this judgment, has gone to Supreme Court. And Honorable Supreme Court has already decided the issue. And has
no, he has not gone to the Supreme Court.
I have not in the Supreme Court. I am not challenging that also.
So he is not even questioning the order. He says the order has missed out the issue arising in his petition.
Then your Lordship, it is to be verified whether it is the assessment order here, your Lordship. The assessment order has been challenged in the writ petition. 4 questions have been framed. Your Lordship, in this, so far as the imported issue is concerned, already Honorable Supreme Court has settled the issue. Even entity tax is leviable on the imported goods.
No, he is not disputing that, sir.
Your Lordship, so far as that local purchase, your Lordship, whether it is to be levied, the purchase, it is to be verified by the appellate authority, your Lordship. So until unless how much is the...
No, then in that case, it has to be remanded. If he has to succeed, then maybe the bench will say remand the matter to the appellate authority for determining it.
Lordship, after this judgment is of 2012.
No, he filed the review petition long ago, but it is not listed.
Your Lordship,
See, he filed it in 2012 itself. We have been digging out all these old cases because it was never listed earlier.
Your Lordship. Your Lordship, then on that
This is covered by the judgment of the Snow White. Totally.
But Mr. Harichandan, did you raise this issue in your writ petition?
Yes, my lord. Kindly have a glance to the writ petition. That is paragraph. Clearly, that is there in page 12, paragraph 24, and that is in the assessment order. He has also averred, and he has disallowed that.
Okay.
Paragraph 24, 25, 26, and grounds is also there. Ground F, G, H.
I know. I'm saying for which the repetition has been do it today itself. Restore the writ petition and send it back to the assessing authority to find out factually if this is correct.
Your Lordship, please, on this point, your Lordship.
Correct. You see,
or your Lordship, let him file appeal on that particular issue. Particular edition, your Lordship. Appellate authority can do well, your Lordship, because the assessment order has been passed. Assessment order here challenged the assessment order in shape of virus. Your Lordship, then your Lordship, let him file appeal on that particular issue. Since other issues have already been considered.
I will benefit only. I will file the appeal again. He will set aside.
No.
Your Lordship.
Yeah. Yeah. He has to produce evidence which has to be examined by the assessing authority. Again, the appellate authority also will remand it only to the assessing authority.
As your lordship please, sir.
All right. The present petition seeks review of the judgment dated 9th October 2012 passed by this court, disposing of writ petition civil 5101 of 2012 filed by the present petitioner. Paragraph. It is seen that the impugned judgment was common to several writ petitions, of which the present petitioner's WP Civil 5101 of 2012 was one. Stop. In para 9 of the impugned judgment of the judgment under review, 4 issues were framed for consideration, but none of those issues pertain to one of the by the present petitioner concerning local purchase of goods from other registered dealers who had brought the scheduled goods in question into the local area. Full stop. It is submitted that while the other issue decided in the judgment about entry tax being leviable on imports into Orissa from Orissa of goods has now been settled by the further judgment of the Supreme Court in appeals challenging the said judgment. The present petitioner was not one of the appellants in the Supreme Court and instead chose to file the present review petition. Paragraph. On a perusal of the judgment and review, it does appear that the issues raised by the petitioner challenging the assessment order on the ground that it did not deal with a question whether it can be levied on scheduled goods purchased inside the local area from another registered dealer of the same local area who brought the scheduled goods into the local area has indeed not been considered. Full stop. Therefore, on the above limited ground and exclusive to the present petitioner, the judgment dated 9th October 2012 in writ petition civil 5101 of 2012 is recalled, and the said writ petition is restored to the file of the division roster bench to be proceeded with in accordance with law. The review petition was above terms. Then a separate sheet to say WP Civil 5101 of 2012. The present writ petition has been restored by virtue of an order passed today in review petition 341 of 2012, recalling the judgment dated 9th October 2012 of this court. Paragraph. The challenge in the present writ petition is to an assessment order dated 17th December 2011, passed by the Deputy Commissioner of Sales Tax, Bhubaneswar 2 Circle, under Bracket C of the Orissa Entry Tax Act for the period 12 September 2008 to 31st October 2010, demanding tax and penalty to an extent of rupees 848,06433 and the consequent demand notice. Paragraph. 1. The perusal of the writ petition, you say this court has heard and counsel the parties. Full stop. One of the grounds raised is that the assessing authority did not consider the question whether entry tax would be leviable on scheduled goods purchased inside the local area by the SSC from another registered dealer of the same local area who brought the scheduled goods into the local area.
Your Lordship, I'm sorry.
and whether there was any obligation on the part of the dealer to furnish Form E1 in respect of such goods. Full stop. In other words, in order to get benefit of exemption from payment of entry tax in respect of scheduled goods, such scheduled goods were brought into the local area by other registered dealers. Would the burden be on the dealer in question to prove that the seller has in fact paid entry tax?
Your Lordship,
Full stop.
Your Lordship, may kindly, on this occasion, the demand has been raised. Your Lordship, may kindly turn to the assessment order, page 27. Your Lordship, Your Lordship, 27 of the assessment order, running page, Your Lordship, is not there. I'm sorry, Your Lordship, page 27 of the assessment order, the paging is in the below of the assessment order, that is at annexure 1.
Yes, page 27. All right.
Your Lordship, why this demand has been raised on this local purchase, Your Lordship, the import purchase, Your Lordship, may place the import purchase of coal during the period under assessment stands rupees so and so. Incidental expenses, duties on such import coal stands and so on. The total value of import purchase of coal, including incidental expenses, duties, stands to be so and so. The purchase, Your Lordship, here is important. The purchase value of coal by instant dealer company from Adani Enterprises, on which the past purchaser has not admitted and paid entry tax, stand at rupees so and so. There is contravention of the stipulation under provision to subsection 2 of section 3 of the Orissa Entry Tax Act. Accordingly, instant dealer company is liable to pay tax at the rate of 1%, and 1% has been levied. Now, Your Lordship, may kindly turn to section 3, subsection 2, Your Lordship. Your Lordship, when that tax has not been paid by the seller, Your Lordship, who was imported the goods to the local area.
Let them find out, sir. Let them find out if that seller has paid or not.
Your Lordship, the finding in the assessment order itself, Your Lordship, assessing officer has already given the finding that this tax has not been paid, Your Lordship, by the importer Adani Enterprises, Your Lordship. And from Adani, it has been purchased by the petitioner. Thereby, Your Lordship, this tax has been levied, Your Lordship. Your Lordship, there is clear contravention of section 3.2, Your Lordship.
Mr. is posing question that has been answered in the question number 3. The answer is there. The liability is on the always on that seller. Kindly have a glance to answer to the question number 3. That is at page 6. In view of the above, we are of the considered opinion that benefit from the payment of interest in respect this judgment. That judgment copy of the of our own court. Page 6. That is at para maybe 9. 361, page 361. Then, in view of the above, we are of the considered opinion that get benefit from the payment of interest in respect of the scheduled goods purchased by a dealer from another dealer, registered dealer of the locality.
Need not prove.
My lord, it will not enough for the dealer to show that it is seller. If it is identifiable, then I have, because here is identifiable. Adani is the identifier, and he is also in same circle in this Bhubaneswar circle. He is also in Bhubaneswar circle.
All right.
So it is identifiable.
It is seen that the assessing officer has also not considered the applicability of the judgment of this court in Snow White Trading Corporation with the State of Orissa, 2014, 71 BST 351 bracket Orissa. So, accordingly, while setting aside the impugned assessment order dated 17/12/2011 and remanding it to the Deputy Commissioner Statute 2 Circle for a fresh assessment in accordance with law.
Considering this judgment also, my lord.
In light of the above judgment, this court disposes of the presented petition.
I may be pardoned, Your Lordship. Item number 59.
1 minute. We have not even completed the dictation here, please.
Sorry, Your Lordship.
The assessing officer is requested to hear the petitioner afresh and pass an appropriate assessment order in accordance with law afresh within a period of 4 months from the date of receipt of this order. Certified copy of this order.
Your Lordship, the petitioner may be directed.
A certified copy, full stop, paragraph, a certified copy of this order be sent to opposite party number 4 forthwith.
Your Lordship, the petitioner may be directed to cooperate in the proceeding because notices has to be issued to the petitioner as well as Adani. Because
no, the petitioner will appear. All right. You say for the above purpose, the petitioner will appear before opposite party number 4. On
I will get the refund if this assessment will complete. Why I cannot cooperate?
1st December 2022. Right.
Your Lordship, as per law, as per section 3(2).
Obviously, sir. Obviously.
Your Lordship, item number 59, we are for OP number 5 and 6.
All right. Just put down the appearance. All right.
Obliged, Your Lordship.
Page 23, is it a notice or is it an order?
It is an order. It is an order.
Okay. Second question, is this an appealable order?
It is an appealable. But, my lords, why I am pursuing, my lords, it is like this, my lords. Admittedly, 142(1)(a) says, before you serve any notice of demand of tax, interest or penalty, then you have to inform the taxable person about this default. And then the assessee gets an option, the taxable person gets an option to either to pay or pay or file his objection. That option is given under section 2A, my lords. Subsection 2 of section 142(1)(a). Now, my lords, after the amendment, can it be said that these provisions have become totally redundant or obtuse because before it was served, now it is made?
No, but all these points, can you not urge in an appeal?
My lords, can your lordship visualize a statutory authority? Appellate authority is a statutory authority. He will interpret the section.
Why not? They do. Day in and day out, they interpret.
My lords, certainly they cannot do. Then second, I am coming, my lords. Now, so far as this Form 3, Return Form 3B is concerned, my lords, this was made available. My period is 1819. That's you may kindly see. This was the period involved is 1st April to March 31st of March 19. Am I able to?
Yeah.
Yes, ma'am.
Yes.
Then, my lords, the GST form 1 is about the total outward supply. Also, that form I have given GSTR 1 at page 2. Lordship will see at page 30.
Yes.
This is the return form where a taxable person will disclose his total outward supply and other things. Okay, this is not the problem. Now the problem lies, my lords, about GSTR 3. This was into force with effect from January 2021. This is a monthly return. Now, this monthly return was not available in the portal. And that form has also, I have given at page Annex 3, page 39. And that is the monthly return as to my total these transactions and input and output ITC.
Well, these are all grounds on which you're questioning the order raising the demand, correct?
Well, your lordship, I'll definitely, my lords, I am lordship, I am quite definite your lordship will appreciate it. This is a case, my lords. The taxable person has been asked to pay the interest unnecessarily. In the portal, this was totally not available. And the allegation is, I have belatedly filed this GSTR Form 3B. Now, GSTR Form 3B was made available with effect from 2020, December 2020. That is, that also I have given my lords, Annexure 5 at page 66. Now, the assessing what the tax, this proper officer writes, lordship may for a minute see this. The returns in GSTR 3B filed by the registered person for the said tax period mentioned below were verified, and it is said that the taxable person has not filed a return in GSTR 3B within due date.
Correct. You say the form itself is not available.
Is not available.
Right.
So let them file a reply, my lords. And so far as that interpretation is concerned, my lords, may have, and lordship knows, will bring only one decision of the Supreme Court. 87 Supreme Court, my lords, page 7.
No. You don't seem to have any faith in the appellate authority.
My lords, okay, I'll stick to ground number 2. They are not available. I have clearly about. Let them file a reply, my lords, that it was made available.
Your lordship, that also the appellate authority is to verify whether available.
No, why?
Or not, your lordship.
Why?
Whose form is available, whose form is not available at that point of time. Everything is because your lordship may kindly turn to that provision of section 75, subsection 12. It is admitted. This interest is admitted and it is recoverable.
Provided that is available in the portal, how can I file my return? It's made available. Make available. Well, the GST Act is such a complicated act. Well, it is not expected that every dealer will come every day they make a notification. Every day. And Justice Rahman has written.
I'm told the lawyers and auditors are very happy.
Let them file a reply, my lord. Fix a date, my lord. Yes.
Applicable, as your lordship applicable. And also, there is focus notice is not required, your lordship, at all, because as per 775(2), and it is recoverable as per section 79. Your lordship, it is very clear. And the assessing officer, your lordship
will kindly see. 69 speaks about return.
Sir,
now so far as Form 3B is concerned, there is mere information. It is not a return also.
All right. Permitting the petitioner to file an appeal against the impugned order and reserving all the contentions raised in the present petition to be urged before the appellate authority in accordance with law. The court disposes of the writ petition. If the appeal is filed, is that barred by limitation now?
I think it is
filed not later than 15th November 2022, accompanied with an application for coordination of delay, citing the pendency of the appeal petition as the reason for the delay. It will be considered in accordance with law by the appellate authority. The court clarifies that it has not expressed any view in the matter.
My lords, may I pray another thing, my lords? I'll also file an interim stay of this. And
it will be open to the petitioner to seek appropriate interim directions before the appellate authority in accordance with law.
Till the disposal of the interim application, my lords.
This is the vintage. Try to see how much it can be.
On deposit of the pre-deposit, the balance amount is automatically stayed, your lordship.
It's all right. I've not said anything. All right.
We are all aware of the provisions. Thank you, Mr. Misra.
Item number 67.
66,
yeah,
68.
67.
67 now.
Item 67, my lordship.
The
petitioner is having a limited prayer, my lordship, where appeal has been dismissed on non-submission of certified copies. It is the covered matter, my lordship, if remember, in my lordship's orders is Jagannath Traders and in Atlas PVC Pipes Limited by my learned, my Honorable Justice Raman, my lords.
All right.
I have submitted to the court master, my lordship, the judgment copy.
Right.
My appeal to be
Yes, Mr. Mishra.
Yeah, let's see.
You say in judgment 29 June 2022 in writ petition civil 14163 of 2022 and the order dated 7/6/2021 in writ petition civil 15061 of 2021 bracket Mr. Sri Jagannath Traders versus Commissioner of State Tax Odisha. This court disposes of the writ petition with the direction
let him submit the certified copy within a specified period.
Setting aside the impugned order dated
May 2022.
23rd May 2022 passed by the Joint Commissioner bracket appeal CT and GST Cuttack 1 City Circle and directs that the said appeal now be entertained on merits and disposed of by the said authority by reason not later than 14th February 2022. For the above purpose, the said appeal, that is what is that appeal number? It's a long number.
My lords, the reference number is at annexure 5, my lordship.
I know, but that's some 12-digit number.
My lords.
Said appeal.
ARN number something.
ARN number AD 210421003 913S will be listed for directions on 14 November 2022. All right.
Item number 68.
Pay it legal losses.
Sri Metallics again.
It is Sri, my lords. Sri means Lakshmi.
I know.
My lords, the question in
Yes, I'm Assistant Commissioner in the
department. No, you are in this case.
Yeah, we are in the case. I'm representing the department.
Okay. My lords, the issue involved in this case added by your lordships in one case.
I see.
An identical issue.
Okay.
That is, I have given this. My lords, a compilation is The issue is, my lords, whether GST on royalty can be levied at the rate of 18% with retrospective effect. That is, with effect from 1/7/2017. At the relevant point of time, my lords, from April 2018 till this notification was issued, I was paying at the rate prescribed under the heading 9970, that is
So
renting out.
on the 7/4/2022 order.
Yes.
All right. You say,
and lords, the questions have been framed in
I know.
para 9 page 50.
Para 9. Correct. But we just list it along with that. When is this coming up?
Lords, may list it along with that.
When is it coming up? There must be a date for this. You say notice. Who will be appearing on your behalf?
Sir, we have not yet assigned it.
Mr. Misra is there for the.
I'm for opposite party number 2.
Okay. Mr. Misra accepts for opposite party number 2. There is a representative. What is your name, sir?
I am Satyaprakash Rao, sir, Assistant Commissioner.
Satyaprakash Rao, Assistant Commissioner,
CGST Department.
CGST Department.
Copy of the order.
Who accepts notice for opposite party number 1?
Yes, sir.
Opposite party number 1.
Yes.
Notice to opposite parties 3 and 4. Actually, that would be Mr. Chimanka, I think. GST Council will be Mr. Chimanka, I think.
Yes.
No, Mr. Chimanka accepts notice for respondents 3 and 4.
Sir, small submission, sir. They have bypassed the appellate channel and approached this board.
Oh.
Yes.
But is there an appellate forum?
Yeah, we have the appellate authority.
I'll point out a judgment of the Supreme Court where identical issue is being admitted. The High Court cannot dismiss. That is AR 87.
Anyway, when that matter comes up, you can make this submission.
AR 87 Supreme Court, page 1345, page 17.
List along with writ petition civil 3181 of 2022. On when is that coming up?
They have not filed. They have not filed their objection in that case, my lords.
2nd November. Oh, it's just around the corner, sir. 2nd November.
2nd November. My lords, till then, my lords.
Yeah. No coercive action will be taken against the petitioner till then. 2nd November is just around the corner. 3 days. You have deposited that 5%.
Yes. And that is admitted.
All right. Okay.
That is admitted.
All right.
5%, then again 13%.
All right.
Sure. Much obliged.
All right.
Much obliged.
Item number 16.
May I please, my lords?
Yes.
I've removed both the defects.
Okay.
The copies.
All right.
Here, my lords, the so motor revision order, my lord, of the Commissioner of Sales Tax is under challenge, my lords.
Okay.
The facts of this case, my lord, is the petitioner is a dealer of petroleum, my lords. Previously, he was a dealer of SR. Now it is the Naira, my lords. What has happened, my lord? He tried as long when he started to his business, my lord. Initially, petroleum products was given to him from Paradip ports, my lords. For a certain period, my lord, it was given from Vizag, my lords. That is with the quarter ending March 2019 till quarter ending March 2020, my lords. Then immediately, my lord, interstate transactions began, my lord. I applied, my lord, for a registration under the CST Act. Initially, I was a registered dealer under the VAT Act since 2017, my lords. Unfortunately, my lord, the GST portal, my lord, was in place. And at all points of time, it said that CST registration is not available for GST dealers, my lords. And your lordship knows, my lord, in that initial period, there was a confusion relating to petroleum products and issuance of C forms to buy that, my lords. Then Capro's decision, your lordship knows, Punjab, Haryana, which was later on confirmed by the Honorable Supreme Court. Thereafter, a series of instructions from the central government, my lord. Thereafter, my lords, allowed, my lords. But unfortunately, this particular petitioner was not given a registration at the relevant point of time. Much later, if your lordship would kindly annex 1 at page 24, my lord, he was given a registration number at page 25, your lordship would see, on 29th of October 2020, my lord, with effect from 4/3/2020, my lords. Lordship got it?
Right.
And my lords, when I applied for the C forms,
so you asked it from an earlier date.
Earlier date, my lords, because these just, my lords.
Right.
My C forms were refused.
So we'll just issue notice.
As your lordship, please.
Notice.
Your lordship, I am accepting.
Mr. Mishra accepts notice for
all the three parties.
And states that he'll file a reply within 4 weeks.
Your lordship.
Rejoined for the next date.
My present difficulty, my lord, is if I don't give the C forms, Naira is not going to supply me these petroleum products because now they have been taxed. by the government of Andhra Pradesh.
Your Lordship, yesterday evening, I have received the.
No, I don't stand in the way for taking.
Because Your Lordship, for the interim order, I might have an objection, Your Lordship, because Your Lordship, let me file reply, Your Lordship.
Because what has happened, the revisional authority, my lord, originally he permit me to place page 50 of the revisional order, my lord.
Right.
Paragraph E.
Yes.
After going through all the relevant aspects of the matter and keeping the facts and figures available at this end, in view of this forum feels that the instant dealer is running the said business in a regular and genuine manner and deposited the resultant tax on the said transaction interstate. And it was not only because of the technicalities for which the learned STO has allowed him registration under the CST Act on a much later date. Hence, this forum means said dealer is entitled for the benefits as provided under the relevant Act and rules. Therefore, the registering authority so-and-so is directed that after verifying the facts and discharging the tax liability of the dealer as claimed by it, the date of effect such registration to be made from 23rd of February 2019, that is the first day of purchase of such goods in courts of interstate trade and purchase. Now, this file was moved to the head office, my lords, for issuance of C forms. There, my lord, a suo motu proceeding began, my lord, on the ground that you can little realizing the fact that I had made an attempt to get myself registered. And because of these technical glitches, my lord, I could not get myself registered. And especially the fact that these C forms were not being issued to GST registration dealers, my lords, registered dealers, my lords. Now the suo motu, in the suo motu division, my lord, if page 55, they rely on.
No, so if we stay the impugned order,
but I don't get
you'll get the final relief at the interim stage itself.
Because I was only playing subject to what falls from my lords, my lords. Let some issued so that I can run my business, subject to undertaking, my lords, and the final outcome of the writ petition, my lords.
Your Lordship, it is for that previous period, for a particular previous period. Now his business is going on. Now his registration has been granted. Your Lordship, registration has been granted
from 2020. Yeah, from 2020. And so you will get your current C forms you should be getting.
But there's no difficulty in it. Now my problem, my lord, is, your lordship would kindly turn to Annexure 9, page 57.
Yes.
The letter of Naira, my lords.
Right.
They say, my lord, with regard to the following CST invoices, those invoices which is prior to my registration, my lord, enclosed herewith, raised by the company on you, you have been advised on several.
If you make, will be subject to the outcome of the writ petition.
It will be a huge amount, my lords. 84 lakhs, my lord, is the total. Lord, I am paying 2% so far as CST is concerned, my lords. I have paid that 2%. Please. I have paid that 2%. If your lordship would see Naira's, my lord, difficulty, my lord, is Naira does not say that I have not paid I have not paid the tax. I have paid CST, but at the rate of 2%. That is the concessional rate of tax. So if I don't give matching C forms, Naira will not be able to claim this concession, my lords. So a resultant will be, my lords, I have to pay, my lord, the entire tax at the Andhra Pradesh VAT Act, my lords. That is the difficulty, my lords. Because unless I reimburse at the rate charged by the local VAT authorities, my lord, they are not going to give me the supply, my lord, anymore. Some, my lord, modalities can to save the petitioner, my lords.
Hey, 50%, Mr. Mishra.
The demand, my lord, would be Naira's demand, my lord, raised by the Andhra Pradesh authorities. So far as Orissa case is concerned, my lord, this is an interstate transaction, my lord. So Orissa, there's no difficulty so far as state of Orissa is concerned. My difficulty is the demands made by Naira and the reimbursement by the petitioner for Naira's demand raised by the Andhra Pradesh authorities. So unless I give C forms, my lord,
your lordship,
I was just praying, Lord, let my learned friend take time, but let it be at least 2 weeks. Let him take instructions, because the revisional authority, as the additional commissioner of Jajpur, my lord, he realized the problems. That's why he said,
my lord, I'm very sorry to My lord, yesterday night,
No. So he says you could file a reply in 2 weeks.
yesterday night, the copy has been given, even if it has not been given.
Sir, please, sir, I'm not making an unreasonable demand. I'm only saying, please take 2 weeks. I'm not asking for more.
Your lordship, so far as the interim order is concerned, so far as
I'm not praying for an interim order. I was just praying to your lordship that some modalities can be worked out to save the petitioner from running his business, my lords. Because of these past liabilities, NARA is not going to supply me because they'll be having a demand for, so far as Andhra Pradesh is concerned, my lords. Because those transactions, 2% CST, if I don't give matching C forms, my lord, they'll be charged.
No, and suppose we pass an interim order, the Andhra authority has to be made a party. Because ultimately they will
the C forms have to be C forms have to be given to me in Orissa.
I know.
So if subject to
that's the final relief you're asking for.
No, then in that case, my lord, at least 2 weeks time, my learned friend may. So 2 weeks.
We can have it on. Earliest can be 1st December. We'll have it on 1st December. Reply be filed within 3 weeks. Rejoinder for the next date. List on 1st December.
Much obliged.
All right.
Item number 70.
May I please, your lords? I have already submitted one written submission along date chat.
My lord, I have to take instruction, my lord.
All right.
No, case belongs to Sapati. In all the cases, 71, 72, 73, 74.
All right.
Well, interim order. No.
This is not appealable.
No, my lord.
Why?
My lord, this is the matter where I have approached this honorable court earlier in the writ petition, my lord. 8441/2022, my lord. During the pendence petition, my lord, giving him a dead chat in my written note submission, page 2, my lord, kind have a glance, my lord. During the pendence of the writ petition, the department authority has issued a notice under annexure 4, my lord, that is at page 26, my lord. The department authority has issued notice that Ashish Agrawal case is applicable in this case. That's why they are invoking section 148AB, my lord. Then and there, I file a petition before the honorable court for withdrawal of the writ petition. Let me participate in that proceeding, my lord. Accordingly, I have filed my return during the due time, my lord, as prescribed 144AB notice, my lord. When my return is very much available before the authority, they have to pass the order, my lord, saying that the 144AD, saying that whatever order passed earlier, that will be remain stand. So I approached before my lords due to this, and they also imposed penalty on annexure 12. I am not getting any scope to participate in the proceeding, even if I am filing my return. If they could have accepted my return and acted on my return, I have no objection.
No, but why can't you file an appeal? That's the question, sir. All these grounds are available to urge in the appeal.
My lord, in pursuant section 148AB, my lord, section 148 order to be passed. That order has not been passed till date. They're saying that it is deeming provision. When I invoke section 148AB, then whatever the corollary provisions under section 148, that has to be followed.
No, not following of a procedure or a provision is a ground for an appeal.
My lord, where is the order is there? They are saying that earlier order is remains status. How? When in one hand you are saying that you have followed 148AB, then 148AB, then 148AD, then 148, then you pass order. How can you midway say that?
Pay penalty.
We have imposed penalty.
Or at least a notice, Mr. Chimanka accepts notice and replies be filed within 4 weeks, rejoined up the next date. Till the next date, no coercive action shall be taken against the petitioner. 9th February.
All right. Item 71.
May I please, your lordship? Lordships, Lordships, in this present case, my lords, petitioner challenging to the order passed under section 148, capital S subclause D of the Act, my lords, for the assessment year 2013.
This is not an appealable order, is it?
Yes, your lordship, but fact is that your lordship, I may satisfy that lordship kindly. Lordship, in this case, my lords, what happened? On 1st April 2021, your lordships, under the unamended provisions of section 148, your lordships, notice had been issued and consequently, your lordship, assessment order has been passed on 26th March 2022. In view of my lord's order, your lordship, on 11 July 2022, bulk of this notice, since it is issued under the unamended provisions of the Act, this notice is invalid and consequently, your lordship, the assessment order is infructuous, my lords. My lords, what happened? In view of the judgment of the Honorable Supreme Court, my lords, Union of India versus Several cases, my lords, relying on this judgment, my lords, and also on the basis of CVDT instruction, my lords, lordships, assessing officer send me notice under section 148 capital A, my lords. Lordships, in response to this 148 capital A B notice, my lords, I have duly complied this notice, and my lords, without going to the merit of this case, my lords, what learned assessing officer had done, that he relied on that judgment, my lords, that assessment order, which has passed on unamended provisions of the Act. My lords, he categorically denied. Let's kindly have a glance to the 148 AD order, my lords, running page number 13. Let's in
Sir, you're showing me what is wrong with the order.
Yes, your lordship,
you're not answering the question,
sir,
why you cannot go in appeal.
Lordship, in this case, he has issued 148 AD notice, my lords, A B notice, my lords, in the judgment of the Honorable Supreme Court, my lords. Since it old unamended notice was issued, thereafter he issued, my lords, 148 A notice, my lords.
No, question simply to you is this. Annexure 1 is an order passed,
yes,
correct?
Yes.
Is it an appealable order or not?
No, my lords. 148 AD is not an appealable order.
You have said it's 148 A1.
AD, my lords.
Let's look at your Annexure 1.
Yes, my lords. Proceeding under section 148 A D of the Act. This is not.
Challenge. This is like after GK and drive charts, suppose the objections are rejected. You don't again file a writ petition for that.
No, my humble submission before your lordship is that
yes,
in case of notice, he is relying on that notice, my lords, which is under the unamended provisions of the Act, 148 notice. He is relying on that notice, my lords. Kindly have a glance to the 148 AD, paragraph number 9, my lords. Kindly have a glance.
Right.
In the my lords, in this case, assessment has been completed under section 147 of the Act on 26 March 2022, determining total income so and so, after considering the issue in the context for the same assessment year against the notice under section 148 dated 31st March 2021. It will be a mere change of opinion at this stage to reopen the case. Therefore, this is the fact of the case available on record. It is considered that the case, assessor's case, is not a fit case to issue notice under section 148 of the Act for the assessment year 2014.
So how is this prejudicial to you?
Yes, my lords. Lordships, he is relying on that assessment order which is passed.
But he is declining to reopen the assessment.
But my lords, my challenge is also to the assessment order also, that which has been passed on unamended provisions of that. I am challenging to that.
That assessment order is definitely appealable, sir. That assessment order is 100% appealable. Yes. That is an appealable order.
Based on unamended provisions of the Act.
Whatever, still you can file an appeal against that. Whether it's passed under the unamended provisions or the amended provisions, you can always file an appeal against that.
Let's see, in vivo Miler's order is also there on 11 July 2020.
So you can quote all that before the appellate authority, and they will consider it. The real challenge, the present petition, is to Annexure 3, A3, which is the assessment order dated 26 March 2022. Under Section 147, read with Section 144 capital B of the Income Tax Act 1961, dated 26 March 2022 for the assessment year 2014-15. Admittedly, this is an appealable order, consequently permitting the petitioner to avail of the remedy of an appeal against the said order and reserving the right of the petitioner to raise all pleas, including the points urged in the presented petition before the appellate authority in accordance with law. The court declines to interfere at this stage and disposes of the writ petition.
Item 72.
77.
72, 73.
Yeah, same. All right.
Item number 74.
May I please, Your Lords? This is a matter I filed the writ petition against the order of assessment as well as the petition of filed before the assessing officer stating inter alia. The notice has never been issued to me, my lord. In that context, the decision of the Honorable Rajasthan High Court, I have given passing.
Sir, again, same question, sir.
No, same, my lord. It is not same question, my lord. Section 282, subsection 1 has a clear.
Sir, can you urge this plea? Are you barred in law? Just give this back. Are you barred in law from urging this plea before the appellate authority?
My lord,
is there a provision in the Income Tax Act which says such kind of pleas cannot be raised before the appellate authority?
My lord, that plea can be taken before the appellate authority. There is no dispute at all, my lord. Number 2, my in this case, my lord, they have issued a notice under section 148 stating inter alia there is a suppression of 50 lakhs some hours, my lord. But on basement, they make assessment 2 crore 48 lakhs. Even if I am filing my return before the authority, my lord, without considering the same, they have passed the order. Even
permitting the petitioner. Sorry,
section 68 of the ITAC, my lord,
right,
taking inter alia that the whatever deposit made in the bank account,
right,
it is added on section 68,
right,
where the bank account cannot be constituted as the books of accounts. Section 68 has not been attracted at all.
All right.
So they have made an expert assessment order, raising a huge demand. Then I pay now 20%, my lord.
Yes, yes.
So 20% is now be burden to me, my lord. That's the approach, my lord.
That's not the reason. You know that's you see permitting the petitioner. Same order. Right.
But delay may be condoned, my lord.
If the appeal is filed not later than 15 November 2022, accompanied by an application for condonation of delay, citing the pendency of the present petition as the reason for the delay, it will be considered in accordance with law by the appellate authority. The court clarifies it has not expressed any view in the matter.
Item 75.
May I please, Your Lordship?
Yes.
Your Lordship, in this case, the impugn notice by annexure has been subsequently withdrawn by the department. If Your Lordship permits, I can share the screen.
It's all right. So you're withdrawing the writ petition then?
It has become infructuous in view of letter dated 18th October 2022, withdrawing the impugn notice, Your Lordship.
All right. Counsel for the petitioner points out that by a letter dated 18th October 2022, the impugn notice at Annexure 1 stands withdrawn.
Annexure 3, Your Lordship, I may be.
Sorry?
Annexure 3, Your Lordship.
Annexure 3, impugn notice at Annexure 3 stands withdrawn. The writ petition is disposed of as weeks.
Item number 76.
Opposite party.
All right.
76, my lord, covered by your lordship's order that audit objection demand, my lord.
Same order.
All right. Same order. Yeah. I think same dates also.
My lord.
All right. Same order, same dates. All right.
27.
No instructions.
No instructions dismissed. All right.
78 also, my lord, same,
Same
instructions.
Item 79.
None appears dismissed.
I am for the opposite.
All right.
Item number 80.
2 Miller on BC Miller. I am for the OP1 and I'm sorry, Miller, disturbing. I am for the OP1 and 2 Miller.
All right. None
Item
appears.
79.
All right, sir.
80, Tamar. 80. 80, my lord, I am for the OP, my lord.
So he's called out item 80.
80, my lord, I am for OP, my lord, BD.
All right. None appears for the
My lord, in 80, my lord, in 80, I'm appearing. My lord, we had spoken, my lord, the respondent needed some time that informed me that they would be taking time for filing.
Yes, my lord. We have completed the interim order, my lord. We have to file the reply in the main petition, my lord. So it is already ready, my lord.
This is an appeal, sir. This is not a petition.
No, not my lord. In appeal, my lord, we have to file and reply, my lord.
Not necessary, sir. Appeal, you don't apply.
My lord, as instruction from my lord.
What's the matter about you? Tell us.
Matter is about handing over position of a shop room, my lord. We have already handed over in position, but I don't pass over maybe even.
All right. At the request of counsel for the respondents. List on. (21st February).
Grateful, your lordship.
Already complied, my lord.
Item 81.
Well, it is a matter regarding that one under ACTR, right to education, my lord. That is the elementary school, primary school in a rural Odisha, in the district of Baleshwar. It is Phaguna Primary School, my lord. And that primary school has been merged with another school. And this is, my lord, contrary to the guideline issued by the government under Annexure 2.
Was there an interim order passed by us?
No, my lord.
No.
There's
So,
no
which means that in the last 4 years, the school already stands merged.
Yes, my lord.
My lord, that's why my case is that's why we have left the education. The tiny tots are not going to schools and the parents are not educated. They will take them to school. What is the government policy, my lord, under right to education being a fundamental right? They have contrary to the notification. This is not that the school is merged and complete. Will be by clocks of time.
No.
Infrastructures.
This
That is
37 students for 1 minute. You're concerned about 37 students, correct?
37 students, and that was the capacity of that village. That 37 to 40
So what is
students
the current position? Those 37
are going to schools, my lord. Now the small children who are not going to that school because there is a river passing through between the two schools, my lord, and this is the contrary to the guideline. That's a lawsuit. I'll draw to a lawsuit.
No. I just want to know first the facts.
Yes, my lord. Fact is that village has a school since 1980s, my lord. And that
in the last 4 years, what has happened?
2 years there was no school for my lord COVID. And the last order, it is for, as per my instruction, they are not afford to take their children to that school because that's a rural area and there is no provision that the parents will go and they leave for the school and bring them out. So against that, my lord, the right to education has been hampered like anything by this.
Actually, we just want to know, of these 37 children, how many have managed to go to the school, or none of them is going to the school? What is the current position?
But no, my instruction is
Affidavit dated 5th of April 2021 portions to Lordship's direction may kindly seen. That is there on the record. 5th of April 2021.
and they have twice been reprimanded by this court, my lord, because filing false affidavit. In this case, filing false affidavit, every time they're filing false affidavit. And it is admonished by this court that why you have filed false affidavit, and they have filed 2 more affidavits that withdrawing that affidavit. And this affidavit, my lord, this is nothing satya part, that there is no truth in their affidavit. My lord, this is, and it is against that guideline. It is not that whatever they want to do, they will do, my lord. 37 students, admitted students are there, and the guideline says 20 students. And we are 37 students. And it is divided by a river. Tinuan river, my lord. And how can this tiny tots will go and cross that river? And they are.
Have you seen this affidavit, madam? This is an affidavit dated 18th March 2021, filed by the District Education Officer, Baleshwar.
My lord.
Can you just read paras 4 and 5?
My lord. My lord, that para 4 says, this is a deponent humbly states that Phaguna Primary School has already been merged with SP and UP. That is forcibly they are saying that merged in Khaira block, and accordingly 37 number of students from class 1 to 5 of Phaguna Primary School, that is the satellite school, were studying in the lead school. From 37 number of students of one Prabhas Kumar Raut in class 5 has already taken TC from SP UP school, and he is prosecuting study in another school. Now there are 36 students are studying in the SP UP primary school Phaguna. The copy of the attendance register is annexed to this was manipulated document. That my lord, all the students who are studying in SP upper primary school Phaguna.
No, just see this. All students are studying.
My lord,
are getting benefits of MDM regularly without any interruption.
My lord,
they're also getting dress materials, study materials.
That's totally manipulated things, my lord. They have created all the documents. That is my stand in this case.
Orally, you cannot say that. See, we are after all a red court. We are a red court. One party has filed an affidavit, placed in the documents. See, you have an option if you want to counter all this to say this is a forged.
I have filed an affidavit, my lord. Each student's affidavit.
No, have you filed a reply to this affidavit?
Yes, my lord.
When?
That's that's in April, my lord. I have filed an affidavit, a reply affidavit to an affidavit filed by the opposite party number 5. Srimati Lakshmi Priya affidavit made.
When did you file it?
Lakshmi Priya Rao.
When did you file it, please?
Date is not. This is 18/3. Must the copy, office copy is it? That's with all the.
No.
My lord,
passes your mind.
My lord, I'll just substantiate that which guideline they are issuing, which guideline they're using to merge the school. That is not that guideline supports us, our case. And now they have issued a corrigendum that this is only in less than 20 students, not in case of
Where is the
building
affidavit?
is there.
Where is this affidavit? When did you file it? Oh, 1 minute.
That's only, my lord, affidavit made by the parents that they are going to prejudice. The date is not in my office copy.
We don't seem to have any such affidavit. Mr. Mahapatra, do you have that affidavit?
No.
Is it reply filed by her to the DEO's affidavit dated 18 March 21.
Rahul.
That affidavit is not there. In addition to that, we have also filed another affidavit on 5th of April, 2021.
That affidavit in reply to my affidavit, my lord. Affidavit after affidavit they are filing to cover up their mistakes.
This is not a reply to that affidavit.
My lord, that affidavit which they have filed.
Pursuant to the order of this honorable.
That is in July they have filed. Well, in July affidavit they have filed that it is submitted that the petitioner had filed an affidavit on 16/4/2019 stating therein Phaguna Primary School possesses its own land and school.
About 5/4/2021.
High 4/2021.
Paragraph 4 and 5 in this affidavit also paragraph 4 and 5. Inquiry report is also appended there too at page 4. And moreover, with regard to merger, the one writ appeal is pending before our lordships.
That is challenging the merger. I am not challenging. I am saying that I am covered by that guideline, that the government notification. Still then you are occupying and forcibly merging that. That writ appeal is pending. That's
page 4 is the detailed report. The inquiry was conducted by the BO, ATO, CRCC, and another ABO.
that's the false affidavit, that ABO.
Everything.
That's why this court stated that filing false affidavit why you have not punished, and that is a personal appearance of the DO. And he appeared and begged for unconditional apology, filing false affidavit.
33 students' names are confirmed now. 33 are there in the attendance register.
My lord, the question is whether, my lord, that as per whether that merger is as per that in terms of that guideline. My lord, they wanted to occupy that school and that building. There is a school and there is a building, and there is under the blackboard Abhiyan, my lord, there was the expansion of school, and Sarva Shikha Abhiyan also granted fund to expansion of the school building. It is, my lord, right to education, and that after this has been more than 100 meters, that is the government guideline that it cannot be more than 100 years, that two schools, and these two schools are divided by one river, my lord, also. It is for betterment of that area, my lord. This is not that what about these 37 schools? My lord. My submission before your lordship is that school must be that the policy of the after Act, my lord, right to education, school must go to the doorstep of the students. You cannot take out a school from the village, and it is divided by a river, and that is the building constructed for the school, and there was the land, everything is there, and they have admitted in that counter that we have filed a false affidavit, and they have begged for apology before this honorable court for filing false affidavit. There was no Pakka building and this thatched. So that intention is to, my lord, mislead this court. And as per my lordship says that, my lord, my affidavit, in reply to my affidavit, they have filed another affidavit.
Correct.
So that affidavit they have admitted, yes, there was by telephoning instruction we have filed that counter, but they have admitted that there was the Phaguna Primary School possessed its own land and school building stands about the suit land bearing khata number 107, plot number 271 in Mouja Phaguna Tahsil, Khaira and Baleshwar. If there is a school in existence and functioning in the village, in a rural village, my lord, and what is the necessity to merge it, and it is not coming under that merger policy? There must be less than 20 students. It is admitted we have 37 students are there, and every year another 30-35 students are coming. And that is been divided by a river, Tinimuhana river. And their ground, their please, it is in the summer, it is dried up. It is that plea in the counter because that is the river, but it in summer it is dried up. In rainy season, student will not go.
My lord, your lordship has already seen the inquiry report.
Yes.
In addition to that, as my learned friend is submitting that with regard to contention of the affidavit has been false, but the contention of the petitioner in her rejoinder dated 25/1/2019, it is the declaration of the petition that the averment assertion contention made in the read petition are totally false. This is they are saying that the read assertions are false. And the inquiry was conducted and the written documents, so representations of the each parents have been enclosed here within the affidavit dated 5/4/2021. And moreover, according to the rationalization policy keeping in view the Right to Education Act, this merger has been done. So this is a purely policy matter of the government. And none of the student is being deprived of getting the right to free education. Right? The parents have also stated that we don't know what is the contents of the document in which we have signed. Copy and the representations I have all have been annexed to the affidavit dated 5/4/2021. No, this is a is purely not in a public interest litigation. This is something else,
Yeah.
man.
This is not a public interest litigation. We are the person aggrieved.
It will not file in the term of the PIL rule, man.
It is not a PL. It is wrongly mentioned as PL. We are person aggrieved, my lord. We are parents of the tiny tots.
So you are now saying it's not a PIL.
No, it is the aggrieved, my lord. Those are the petitioner. Their children are studying, prosecuting. It has been treated as a PIL. I don't know why it has been treated as a PIL.
4 years after functioning properly,
It's 43 of their
No, if you say it's not a PIL, we'll put it before the roster bench then. During the course of arguments today, nearly 4 years after the petition was filed, the counsel of the petition insisted that this is not a PIL and it has been wrongly mentioned as a PIL. In that view of the matter, the petition is directed to be listed before the roster bench on 8th December.
Item number 82.
But I am on VC, my lord. But last occasion, my learned friend has submitted a memorandum annexing 2 documents. That is a paper cutting of reportedly, it has been reported on 29th.
Sir, why are you not in the court today?
Lord, I am sorry, Lord. Lord, 2 matters are there. So, Lord, I am not. Lord, I am sorry, Lord.
How will you, madam, how will you hand over documents?
Your Lordship, I have already received the copy of the affidavit yesterday. May I place your Lordship?
Lord, the counter affidavit, Lord, I have filed yesterday. Lord.
It's not come on record. And you're not in a position to hand it over also in court. It's all very unfortunate, sir.
Lord, I have filed on Lord, e-filing mode, Lord.
It is not come on record, sir. What is the statement you're making today?
Your Lordship, may I pass it over in the meantime?
I submit, Lord. on both the two documents my Lord and friend relied upon. The paper cutting, my Lord, relied upon, which was published in the month of September 2020. In the meanwhile, we have developed the booking and fitment, and nowadays, at least 20,000 booking is already made per day, and the fitment is also 20,000 per day.
So you put off your enforcement action at least till it all gets stabilized, and people are able to access.
In the meanwhile, the date has been enhanced to another 1 month. Till date, there is no enforcement.
All right. Till which date have you extended it?
But that is under Annexure D/2. That is not your people. I'm sorry. But now the date is to another 1 month. That is up to 31st/11/2022.
There are no 31 days in November. I think you've added a day. The country will be very happy to know that only in Orissa 1 more day is added in November.
No, 30th November.
All right.
I'm sorry.
All right. You say council.
May I be permitted to place your lordship?
No, we'll take it up on 28th or 29th. So,
Lordship, just a few days before the ending of November would be.
That's what, 28th. We'll take it on 28th.
Obliged to lordship.
You say the counter affidavit of the transport commissionerate be placed on record. Stated to have been filed, be placed on record. Counsel appearing for the transport commissioner informs the court that the deadline for getting the HSRP registration plates has been extended up to 30th November 2022. List on 28th November.
Obliged to lordship.
Item number 83.
So may I please, my lords?
Yes.
This case, petitioner has challenged the constitutional validity of section 28 small a of the Orissa Value-Added Tax Act. So in the meantime, counter rejoinder has been filed, and after filing of rejoinder, my royal friend has filed reply to rejoinder, and your lordship on the last occasion directed that pleading shall be completed after giving me permission to respond to that. Now I pay your weeks time to file that reply to the affidavit filed by your royal friend, and after that, as your lordship direction, pleading will be complete, and your lordship will fix up a date for filing. That is my humble submission.
Mr. Saul, senior counsel, states that he will file a further reply to the last affidavit of the state before the next date. It's made clear that the pleadings will be complete with that, and no further affidavits will be permitted. List on 2nd February.
Item number 84.
In item 84, I am appearing for the petitioner. I just want to place a small synopsis to bring to the notice of your lordships regarding the development in this writ petition. During the pendency of this writ petition, there was a challenge to the constitutional validity, and this has now been settled by the Honorable Supreme Court. So here the writ application the validity of the notification, retrospectively amending Rule 89(5) of the rules. The said notification was declared ultra vires by the Honorable Gujarat High Court, and the Honorable Chennai High Court had taken a contrary view, and both this judgment was subsequently carried in appeal to the Honorable Supreme Court, and the same was finally decided on
39/2022.
Yes, 39/2021. 39/2021, milords. And I have placed a small date chart just to bring to the knowledge of your lordships regarding the subsequent development. In respect of the monthly refund claims for the period July 2017 up to January 2000, petitioner was granted the refund-wide final orders indicated in form of a statement which has been enclosed as Annexure 1, and the sample copies of the refund orders are enclosed as Annexure 9.
Then, my lords, a writ petition was filed for this honorable court challenging the constitutional validity. Then 3/7/2019, during the pendency of the present writ petition, the petitioner was served with a notice dated 3/7/2019 by the opposite party number 3, seeking recovery of the refund already sanctioned for the period relating to July 2017 to January 2018, amounting to 18.18 CR. Request and penalty. 8/7/2019, an additional affidavit was filed by the petitioner stating the above facts, and the notice has been annexed as Annexure 7. 8/11/2019, order was passed by the opposite party number 3, treating the refund already sanctioned as erroneous and thereby sought to recover the same along with interest and penalty amounting to rupees 19.99 CR. This order has been annexed as Annexure 10 to the writ petition. Then on 13/9/2021, Honorable Supreme Court in the case of Union of India has upheld the constitutional notification. In short, the appeal filed by the Union of India against the judgment of Gujarat High Court.
But the idea of the retrospective amendment is only to deny you the refund.
Yes, my lord.
So how can you get the two prayers if the notification is upheld, sir?
Yes, my lord. So therefore, I have limited my prayer. Subsequently, I have stated, my lords, in view of the aforesaid development, a memo was filed with the petitioner for this honorable court stating that insofar as prayer number 1 and 2 are concerned, they do not survive in view of the judgment dated 13/9/2021 of the Supreme Court. And taking note of this development, court had passed an order on 29/11/2021, my lords, that the counsel for the petitioner points out that there are 4 prayers in the present writ petition. As far as prayer number 1 and 2 are concerned, they do not survive in view of the judgment. Sorry. Sri R.S. Chimankal, and senior standing counsel for the OP number 3, states that he needs some time for instruction, so and so. In prayer number 3, the prayer of the petitioner was to direct the OP number 3 not to deny refund already sanctioned to the petitioner in respect of the GST paid on input services starting from July 2017 to January 2018 in the garb of retrospective amendment.
Can prayer be granted? The retrospective amendment has been upheld by the Supreme Court. The idea of the retrospective amendment is only to deny you this refund.
Yes, my lords. Therefore, I have limited my prayer only to prayer number 4 of the writ petition. If your lordship had accepted that both the prayers could have been heard, but since your lordship have rightly pointed out, in view of the retrospective amendment, I mean, the refund which has been already been sanctioned, they can also be sought to be recovered. But here, my lords, I have a small submission of your lordships. If your lordships would kindly turn to page 21A of the writ petition, my lords. In view of the amendment, a consolidated writ petition was filed. Therefore, I will draw your lordship's kind attention to page 21A. It is at paragraph 17, my lords. In consequence to the notification dated 18/4/2018, 13/6/2018, retrospectively amending Rule 89(5) of the rules with effect from 1/7/2017, the opposite party number 3, via Annexure 7 to the writ application, served a notice upon the petitioner seeking recovery of the refund already sanctioned for the period relating to so and so, along with appropriate interest. The submission of the petitioner, the recovery proceeding which has been initiated by the OP number 3, is without jurisdiction, since the opposite party number 3 has himself sanctioned the refund. Therefore, the recourse which was available with the authority was to for the appropriate authority in the prescribed form in terms of section 1072 of the CGST Act, read with the rules framed thereunder. But in the instant case, my lords, my humble submission is that the opposite party number 3 has directly initiated the recovery proceedings by way of issuance of the so-called notice.
Because of this retrospective amendment, sir.
Yeah.
Because of the retrospective amendment, he is issuing a show cause notice.
But there is an appeal provision under 7107.
Appeal. Once the law itself has changed, retrospectively, the amendment has been made. But obviously, the refund order cannot stand.
But during the relevant period, whatever was the law prevailing then,
that's okay.
The provisions of Rule 89(5).
In tax law, it is only to when we say with retrospective effect from, it is to nullify everything that has happened in between.
Yes, my lords. But I'll just show your lordship. Yes, my lords, I just have to point out to your lordships relating to the interplay between section 73, which is the provision dealing with issuance of the so-called notice, and section 107. This interplay of section 73 and section has been dealt with before also during the central excise regime, where the parametria provisions there were section 11A and section 35E, my lords. And to that effect, my lords, with your lordship's kind permission, may I just place a judgment of the Honorable Allahabad High Court, which is also, taken care of the judgment of the Madras High Court and the Andhra Pradesh High Court, my lords. If your lordship would kindly see the paper book of citations, which is for your lords.
Is it?
I will take your lordships to page 67. It is a paper book of citations, my lords.
Right.
Yes. I'll take your lordships to page 67. It is the judgment of Allahabad High Court in the case of Honda CL Power Products versus Union of India. The question of law is at page 8, is at para 8. The question of law which was there for the Honorable High Court is at page 21.
21 or para 21?
Sorry. The question of law, I'll take your lordships. Sorry. Page 72 at para 31. Which is at page 72, para 31. Thus, the question for consideration for us, whether you can initiate the proceedings under section 11A, the parametria provision under the CGST Act is section 73, my lords. For recovery of excise duty, once adjudication has been made by the department making final provisional assessment, and thereafter adjudication application, and thereafter adjudicating application for refund under section 11B, here the parametria provision is section 54 under the CGST Act, and no appeal being filed challenging the said adjudication, which having attained finality is barred on the ground of change of opinion or would amount to reassessment when once the revenue did not take recourse to appeal in higher forum. The provisional assessment order, adjudicating authority passed an order for refund under section 11B of the Act. Both the orders which were appealable and revisable under section 35 and 35E was never taken to the higher forum by the revenue, and they attained finality. It was only after the decision of the apex court in case of Addison and Company that so-called notice was issued on 17/8/2017, and an order was passed directing the petitioner for refund of excise duty to be deposited in the Consumer Welfare Fund. A careful reading of section 11A, 11B, section 35 and 35E would reveal that an application for refund as envisaged under section 11B is not to be dealt as a ministerial act or an administrative act. An application has to be made by a person claiming refund within a prescribed time, and the application is to be accompanied by documents referred to in subsection 1 of section 11B to establish that amount of duty of excise and interest, if any, paid on such duty in relation to which refund is claimed was collected from or paid by him, and the incidence of duty of interest, if any, paid on such duty has not been passed on by him to any other person. It is on the receipt of this application, the Assistant Commissioner or Deputy Commissioner of Central Excise, if satisfied, may make an order for refund. Thus, it is only for the adjudication of the application that the order of refund of duty on interest is passed. Subsection 3 of which is a non-obstant clause, makes it clear that derogates any judgment, decree, order, or direction of appellate tribunal or court or any other provision of the Act, no refund shall be made except as provided in subsection 2. Thus, the procedure prescribed under 11B not only regulates the manner and form in which the application for refund is to be made, but also prescribed period of limitation as well as method of adjudication.
So only one possibility exists, sir. If you want to reserve all these points, you want to urge it in reply to the show cause notice, by all means you do that.
We'll
adjudicate what you're now arguing your chance before the authority will get foreclosed. Because after we have expressed our opinion on this submission of yours, whatever you file as reply to the show cause notice will become redundant. That authority is not going to say, I differ with the two judges of the High Court. So that you make up your mind. By all means, argue to your heart's content. We will not stop you. Cite all the judgments you want to. But when we start dictating the order, dealing with these submissions, at that point, don't say, I want to withdraw to go before the authority in reply to the show cause notice.
Milords, I leave it to the judicial.
Oh, that is very kind of you, sir. But you're not answering the question.
Milords, so yes, your Lordship may indicate. I mean, your Lordship may indicate. I mean, this is what is the position.
No. After hearing you for 1 hour, we will not simply indicate. After hearing you for 1 hour, we will pass the judgment.
No, Milords, I am leaving it open for your Lordship.
No. That is, this is a mutual exchange.
It is.
We are leaving it open to you to make up your mind. You say, no, I will leave it open to you to make up your mind.
Milords, I leave it.
We are supposed to. No. You don't have to leave it to us. We will anyway get here only to decide.
Milords, as it is falling from your Lordship's, Milords, I am open for the idea. I mean,
no question. Open for the idea and all. You make a statement saying you'll withdraw this plea right here to reserve your to answer in the show cause notice. Otherwise, we'll decide the point.
Let's. So Lordship, but direct. I'll take this and reply for the authority.
All right. Today, in the course of hearing, you say this court has already, in its order dated 29 November 2021, noted as under. Reproduce the order. Paragraph. Today, in the course of hearing, counsel of the petitioner also did not press prayer number 3, which was for a direction to opposite party number 3, not to deny the refund already sanctioned to the petitioner in respect of the GST paid on input services starting from 2017 to January 2018 as a result of the retrospective amendment to Rule 89, Bracket 5, paragraph. However, counsel for the petitioner said that the petitioner is still pressing for prayer number 4, which is a challenge to the show cause notice issued to the petitioner on 3rd July 2019, seeking recovery of the refund sanctioned for the period from July 17 to January 18. Full stop. The petitioner sought leave to urge before the authority which issued the SCN in reply thereto all the pleas in that regard that are available to the petitioner to be taken in accordance with law. Stop reserving the right of the petitioner to do so. The petition is disposed of.
I am appealing the opposite party.
All right.
Mr. Chimanka appear.
All right, sir.
Deeply obliged.
All right.
Item 85.
Your Lordship, item number 85, I am appearing on behalf of the opposite party, Your Lordship. I may pray also, I have filed a miscase. Your Lordship was directed for production of the record, Your Lordship. And Your Lordship, on the last day of hearing, the record has been misplaced, Your Lordship. For that, many proceedings have been initiated during the year, during that period, Your Lordship. To my clerks, also office bearers, everything, Your Lordship, we have already initiated. So on last, Your Lordship, may 2 weeks time to take the final instruction from my office, Your Lordship.
All right. The request of Mr. Mishra and counsel of the department, who needs some time for instructions. List on 8th February.
Your Lordship, interim order is there, that may be continued. Your Lordship.
To continue. Yeah, interim order to continue.
8th February.
Item number 86.
Obliged.
Because in this case, the questions are framed at 13. Your Lordship, by order dated 12/4/2022.
I'm sorry, before starting of my law and senior, Your Lordship. Your Lordship, on the last occasion, Your Lordship has directed, since it is an appeal, Your Lordship, on the last occasion, Your Lordship has directed to file a submission, Your Lordship. Your Lordship, I need some more time to file the submission.
Yes, 87.
No, I am on 80.
I'm sorry. I think I 87.
The wrong matter.
I'm sorry.
86.
No, no.
Let it be come next 15 days.
All right, at the request of Mr. Chimanka.
Milords, I don't object to my friend's suggestion, but what I am submitting, Milords, your Lordship, by order dated 12/4/22, was pleased to issue notice directing the parties to file by counter and respond by filing rejoinder, and those have been complied with. And though Lordship have issued notice, but as my Lords know, under 260, matter is permanently admitted, Milords. Matter is yet to be admitted. Milords, questions are being framed in this application at page 18, but there are 4 numbers of questions. Milords, to minimize unnecessary, Milords, I have substituted 2 questions only. That I am giving to my Lords. I have sent to the court, Milords. My Lords may kindly.
Let's see that. Let's see that.
Only 2 questions are there. My Lords may kindly.
Copy may kindly be served, my Lord.
Yes, yes. Sir. And also, all judgments I have given, I will pass on copy of all the judgments also. Judgments I have done. 2 only.
Oh, share application money. This is never ending. Section 68 and share application money.
Yes, yes. Money has come to banking channel from outside the country.
This question number 2 is a.
This has been.
Is a standard question, sir. It's effectively there's only one question. So only effectively one question. You say put this appeal ITA 14 of 2020. You say admit the following question of law is framed for consideration. Whether the income tax appellate tribunal was correct in law in sustaining the addition made by the assessing officer under section 68 of the Income Tax Act 1961 in respect of share application money relating to trading limited bracket a foreign company question mark. That's it. Right, we just say in a separate order, in the order dated 12th April 2022, the word single quotes writ appeal occurring in para 1 should be substituted as appeal. And in the caption below that, the reference must be to ITA number 14 of 2020 and not WP Civil 14 of 2020. Type this as a separate order. You see, the interim order passed with this court in the main order. The interim order passed with this court on 12/4/2022 is IA number 17 of 2020 is disposed of. We'll list this appeal in due course, sir. There's no hurry. List in due course.
It's a long pending matter. What I am praying, subject to Lordship convey any judgment, but the date may kindly fixed.
All right. All right. This for final hearing on 20th February.
Obliged, Milords. I think today I would obliged.
Item 87.
I'll just seek
once my Lord and Senior, Mr. Sahu, appear in the. So I thought it is my matter, Your Lordship. Your Lordship, item number 87, I may pray a 2 weeks time adjournment, Your Lordship, because it is an appeal. So I may be permitted to file a submission, Your Lordship.
All right. Written order submissions be filed by Mr. Mishra for the department before the next date. This on 21st February. Is there interim order?
Milords, I'll just seek your Lordship's kind.
1 minute.
Order dated 24/2022, my Lord.
Yeah. Interim order to continue. Correct.
Yes. 21st February.
Yes.
Let's say that item 84, your Lordships have directed us to file a reply to the show cause notice. But if your Lordship would see the date chart which I have just submitted, notice it at 3/7/2019, and that is under Annexure 7. But in pursuance to that show cause notice, there was an order for recovery which was passed, which is under Annexure 10. So unless and until that order goes, I will not be able to file a reply to the show cause notice, Milords. And this order was passed during the
No,
pendency of the
that order was passed without your filing a reply or after you filed a reply?
No, my lords. We could not file a reply because of the pendency of the writ petition for your lordships. And that show cause notice was also by way of an amendment, was also challenged for your lordships, lords. My lords, the date is 8/11/2019. That is in the date chart. Order was passed by OP number 3, treating the refund already sanctioned as erroneous and thereby.
But you did not challenge this order in this writ petition. Have you challenged this order?
Yes, it is annexed 10, my lords. I have challenged both the show cause notice as also the order which was passed, because both these events have taken place after filing of the writ petition for your lordships, my lords, and during the pendency.
Then you have to only argue why this order is wrong. This order must be saying that because of the refund is payable.
Lords, I'll simply say that if your lordship would give us an opportunity to file a proper reply, as your lordship.
No, but what is the final outcome of such a reply?
But the order again, I mean, when there is already an order, lords, that will be an impediment for me.
It shouldn't become an empty formality, sir. No. I thought there was no order.
Lords, I've indicated here, lords, and
it will only become an empty formality. In fact, it's linked with prayer 3 itself, because the same period.
Lords.
In that case, you just take out that. Just the only prayer that is being pressed at this point is prayer number 4, which is a challenge to both the show cause notice dated 3rd July 2019 and the consequential order dated 8 November 2019, passed by
OP number
the
3.
Assistant Commissioner, CGST and CX, Cuttack 2 Division, asking the petitioner to return the refund amount together with interest and penalty. No, only with interest. There's no penalty.
There is no penalty.
Together with interest. Full stop. Since the full stop. Counsel to the petitioner states that the petitioner was unable to file a reply to the SCN dated 3rd July 2019, and therefore the order dated 8/11/2019 was passed without petitioner filing a reply. Paragraph, be that as it may, the refund has become returnable by the petitioner as a result of the retrospective amendment to Rule 89(5) the CGST Rules 2017. Stop. With the retrospective amendment being upheld by the Supreme Court, the recovery of the refund amount is but an automatic consequence. Stop. The mere non-filing of a reply by the petitioner would not make any difference to the result. Paragraph. Consequently, prayer 4 is also rejected. The petition is accordingly dismissed. I think this is better. This way you can take it up further. Right.
It was a duty on my part.
No, thank you. That's fair of you.
Item number 88.
May I please, Malaj, I beg to appear in this.
Yes.
Malaj, the challenge to these writ petitions, Malaj, these are all common writ petitions for the assessment years, Malaj, starting from assessment year 13-14, going up to assessment year 17-18. Malaj, my first challenge, there are 4 grounds of challenge. Malaj, the first is common to all, which is that the officer in Malaj, Bhubaneswar had no jurisdiction to issue me the 148 notice. I am a foreign company, resident of the United Kingdom. I received a notice, Malaj, dated 31st March 2021 for all these assessment years 2013-14 to 17-18. I took a specific objection before the officer, and if my lords will see Annexure 8.
Mr. Chimanka, you appear for the department.
Yes, I'm appearing. Yes.
All right. Yes. Annexure 8.
My lords, and my lords will, that starts at page 148. If my lords will kindly see page 151.
Yes, lack of jurisdiction, Orissa.
Yes, my lords. And I had pointed out, my lords, along with this, my objection, if my lords would kindly see page 163, which is a screenshot of, my lords, the income tax e-filing portal, which reflects my jurisdiction to be in Delhi.
That's right.
I took this plea before the officer. I also pointed out, and my lords, I'm sorry to take my lords back to page 151 for the moment for the sake of completeness. I also told the officer that in the past, I had applied for a lower withholding certificate under section 197. However, that certificate was never put to any effect. No transaction was ultimately consummated using the certificate. This was, my lords, duly disclosed. My lords will see page 151.
Yes.
Where, for the sake of completeness, it is submitted that the assessee had earlier filed an application under 197, which was disposed of by the officer in Bhubaneswar, granting lower withholding. However, the assessee has neither made any transaction nor taken advantage of the lower withholding certificate. Therefore, I made this point. Now, my lords, the officer disposed of my objections on this aspect, stating that I have jurisdiction. My lords, in the writ petition, I assailed this part. For the first time, my lords, if my lords, the affidavit now, which has been filed by the department.
Yes.
My lords, the department has pointed out that there seems to be some order under section 120 of the Income Tax Act, by which the jurisdiction has been transferred to the officer in Bhubaneswar, my lords. And that, my lords, will see that so-called order as annexure 1 to the counter affidavit.
Yes.
My lords, my first respectful submission is this. This is not even an order. This is a proposal which was put up for consideration. The order is not even annexed till today. If my lords will see,
Mr. Chimanka, is there an order, Mr. Chimanka?
No, we have challenged the notice under section 148, my lord.
No. He's referring to annexure 1 to your counter affidavit.
Yes.
And he points out that this is simply a note proposal.
Yes.
Or transfer of jurisdiction, which never culminated into an order. He says you have not produced the order. This is simply noting on the file, which is a proposal.
No. I have filed first a memo, then I filed a counter affidavit. Then he has filed a rejoinder affidavit.
Sir, please answer the question, sir. Annexure 1 to your counter affidavit is not a. It is only a proposal. You see the last line, it says put up for kind proposal.
Yes.
Where is the order?
The transfer order is passed under section 120 of the Income Tax Act, not 127.
No, 120. Where is that order?
The order is the same.
No, where is that order? There is no such order. This is a note put up to the CIT, which the CIT has signed. But there should be an order, consequential order.
And my lords, I will further demonstrate that, my lords, under section.
There has to be a notice, I think, to the SSC before transferring jurisdiction.
There is no power under 120 for a commissioner to transfer file to an officer who's not within his jurisdiction.
That's what.
That power is only under 127.
Correct.
And for that, my lords are right. A notice has to be served to me. If my lords will
Correct.
The annexure 1 is the approval.
No, sir. We are now on the actual order.
This is the order under section, the first paragraph, jurisdiction. The CPT in excess, this is the order. The CPT in excess of power annexure 1 conferred the section 121 of the IT Act has specified the jurisdiction of income tax authority by notification of government Indian CPT notification, so and so. In pursuance to the above, further order were passed under section 120 defining the jurisdiction of assessing officer posted under
under charge of CIT, IT, International Section 1, Delhi, which are tabulated below. Order are placed contra. Alphabetically A and B, company first name, individual surname. F and G, company first name and surname. Company first name and surname. Like this. This is the order, my lord.
No, sir. Please read on. Mr. Chimanka, you should give us some credit for understanding what these notes are. Kindly read para 3 now.
Application have been received from SSE requesting for migration of PAN. In view of the above order, the correct jurisdiction of such PAN is intensely in column 5. Further, it is mentioned that scrutiny assessment in all the below mentioned cases has never been undertaken in the charge mentioned in column 4. It is technically the PAN to the correct jurisdiction. If approved, PAN in these cases may be migrated to the respective AO mentioned in the column 5.
And then please read, put up for kind perusal.
CIT International Taxation in New Delhi.
This is not an order, sir. This is simply a noting in the file.
Yes, my lord. Yes, my lord. Yes, and pass order on 1610-2020.
Do you want to get the file? You want to see for yourself? Is there an order on the file?
Then, however, instruction, my lord, in the case, I will take further instruction.
You say one of the grounds on which the reopening of the assessment under section 148 and 7 of the Act by issuance of the impugned notice dated 31st March 2021 under section 148 of the Act has been assailed by the petitioner is that it has been issued by the ACIT International Tax Bhubaneswar. There is no restriction to do so since the petitioner company has been filing all its returns.
No, Malaj may not say returns because this is the first time I filed my return. Malaj, the jurisdiction allotted by the department is in Delhi.
Since the jurisdictional authority under the Act, as far as the petition is concerned, which is a foreign company, is Delhi, is New Delhi.
Please, Manoj.
Paragraph. In response to this averment, in the counter affidavit by department, the noting on file, a copy of a noting on the file of the department where is the reference to that enclosure? Noting on the file of the department has been enclosed as Annexure 1. Full stop. A perusal of Annexure 1 reveals that it is only a proposal made for transfer of jurisdiction and not actually an order transferring jurisdiction. Full stop. Further, the provision invoked to Section 120 of the Act and not Section 127 of the Act. Full stop. It is not known whether any consequential order was in fact issued under Section 120 of the Act, pursuant to the above noting in the file. Paragraph. Mr. Chimanka, learned counsel for the department, states that on the next date he will produce the file itself together with the order section of the Act, which has been passed pursuant to the noting at Annexure 1. Full stop. It must be noted at this stage that Mr. Jolly, learned counsel appearing for the petitioner, questions the authority of the CIT in Bhubaneswar to pass any order under Section 120 of the Act.
Well, CIT in Delhi, sorry.
CIT in Delhi to pass any order transferring the jurisdiction to an authority outside Delhi, invoking Section 120 of the Act. At the request of Mr. Chimanka, list on 25th January.
Yes.
Grateful.
25th, some
Yes.
other date. Marriage of my relation.
Okay. 6th February, sir.
Okay, okay, Miller.
Grateful, my lord.
Lordship, interim order.
Well, the interim order to continue.
Yes, yes. Interim order.
Item number 89.
My lord, no. May I brief? I have filed a short date chat.
Sorry?
A short date chat I filed. Lordship, can
Before my learned friend starts, with the permission of my learned friend, may I submit one thing?
Yes.
His allegation and his claim is that I am not liable to pay the license fee and the MGQ during the period when this shop was not allowed to be opened. That is the one. So I suggest to your lordship, if this matter can be directed to be adjudicated to the excise commissioner once, let him appear before the excise commissioner, submit all his defense.
May I just subject?
If the excise commissioner will decide in his favor, then it is well and good. If it is not decided in his favor, then your lordship can, because factually there are many things which it has to be dealt with by the commissioner according to my.
All right. Well, lordship kindly have that. There is absolutely no factual dispute insofar as license is concerned. I'm doing with you. I'm consenting to MGQ, the minimum.
License fee he has to pay.
Yes, I have paid. In fact,
okay.
For the entire period, I was allowed to open the shop by the order of this honorable court as well as by the order of the excise inspector. So that being the dispute. This my shop was because of the stay granted.
The demand against shortfall of MGQ.
I have never opened it.
Your lordship is remanding all the cases to excise commissioner.
Let the commissioner take a call.
What will happen here?
Will appear before the commissioner.
And I'll be then the next year it will be due. Today they have given a
no, till then, so far as this disputed amount is concerned, that will not be recovered from you till the decision is taken by the commissioner.
And that will not be insisted for renewal of my license. Because license fee, I am otherwise
renewal. I think
that is where the crux, my lord. That is where they have already filed a counter.
Renewal is not stopped, I think.
They have already filed a counter, my lord. And the only problem is that I have already today, by virtue of the interim order of this honorable court, I am protected.
That will continue till
that is a deferment. The deferment, yes, my lord. The deferment period by virtue of the notification is covered. But what will happen once this notifications period ends? The entire burden will be shifted to me. Lordship kindly have that 2-3 dates. I just may not trouble your lordship. Then I've given it on 10th.
So before the date of renewal, that is March, by the end of December, this commissioner will take a decision.
And then there will become, my lordship may kindly have that date. As every time there is this honorable court has passed the order staying opening up.
Yes, that will continue. That will continue. Within 2 months, the commissioner will take a decision.
Or date chat of 2 pages, your lordship. 17th, on 15/4, I was granted with the license and with 15 days condition to have a shop. On 30th, there is the order of closure. Should not open. And the place which was being used for the shop is now denied to me. Now, then I rushed to this honorable court. And your lordship have directed them to complete the process. Finding it a delay, I made an application for shifting. But that order was also stayed by your lordship. And I could not operate the entire period. Where do I go, my lord?
What do they say in the account?
They are saying that they affirming that in the account.
Our stand is that it is the responsibility
of have that paragraph 8 at page 68. That in reply to the above made it paragraph 12 of the writ petition, it is humbly submitted that initially the license has failed to operate the shop by finding out a suitable private land, and later due to the stay order passed by this honorable court, the licensee is duty bound to pay the license fee. License fee
disputed. I have already paid. And he has also entered into the agreement with the government in this regard and keep
our stand is very
and that
simple.
Since it is
that
there in
according
the
to
license, I have to pay.
They have to pay give the MGQ, soft clipping MGQ, because it is his responsibility to find out a suitable place, private land.
You granted him the period from which he was to operate the shop was 1st May onwards.
Yes,
it is there because
so the
your
stay
lordship
started from 30th April itself and never ended.
That is what I am saying, that which is the period of closure. That is what the commissioner
No,
will
in your
examine.
reply, you dispute that. That's because you don't.
No, they have not disputed. Period has been disputed. And this is also covered by judgments of our own High Court.
You say the prayer in the present petition is for a direction to the opposite parties to waive the demand pertaining to short lifting of minimum guaranteed quantity in respect of the IMFL off shop allotted petitioner. Full stop. It may be mentioned at the outset that Mr. G.M. Rathur, learned counsel appearing to the petitioner, does not press the prayer as far as license fee is concerned and states that the petitioner has in fact paid the license fee for the period in question and is linked to the MGQ paragraph. The background facts are that sale notice inviting applications for settlement of exclusive privilege of IMFL off shop was issued on 17th March 2021 by the Collector Khurda. Stop pursuant thereto, on 15th April 2021, the petitioner emerged as the lottery winner. And license was issued to him to open the shop from 1st May 2021 to 31st March 2022 at Jatni number 2 IMFL off shop at the location of Golai Market, Ward number 6. Full stop. Paragraph. Writ petition civil 15795 of 2021 was filed by a person who could not win the lottery. Full stop. The writ petition was disposed of on 30th April 2021 itself by this court, with a direction to the authorities to consider the said petitioner's representation. Full stop. The superintendent that date itself directed the petitioner not to open his shop. Full stop. On 19th May 2021, the petitioner filed writ petition civil 170 challenging the aforementioned order. Full stop. This was disposed of. This petition was disposed of by this court by an order dated 4 June 2021, setting aside the order dated 30th April 2021 of the superintendent and directing that the matter should be decided afresh by 2nd August 2021. Full stop. According to the petitioner, pending the decision of the superintendent and to avoid the delay in opening of the IMFL off shop, he arranged an alternative unobjectionable and made a request for shifting of the site. Full stop. Although the collector issued notice in Form 8 for shifting of the shop on 7th July 2021, the previous licensee filed writ petition civil 20804 of 2021 in this court, challenging the said notice. Full stop. In the said writ petition on 2nd August 2021, this court passed an order staying the shifting notice. Full stop. That stay order continued till 5th January 2022 when the writ petition stood withdrawn. Paragraph. The net result is that the petitioner was never able to operate the shop, IMFL off shop, at the location allotted in which it was allotted to him for the entire period, that is from 1st May 2021 to 31st March 2022.
No, that is the thing. When he opened the shop, Victor, this writ was withdrawn on 5th January 2022. Thereafter, when the license was issued, and that is to be verified.
That was issued in month of May. That is issued. My lordship record that to my statement. That is issued after
the financial license
after
year.
the financial year.
Mr. Ratha adds that the license for the next license was issued only on 1st May 2022.
In the new location.
In the new location. Full stop. Paragraph. The picture that therefore emerges is that during the entire period from 1st May 2021 to 31st March 2022,
yes,
the petitioner could not operate the IMFL off shop in question at all, and therefore not right to demand the MGQ from him for that period. Paragraph. Consequently, the demand pertaining to the shoplifting the MGQ for the aforementioned period in annexure.
That is not annexed.
The demand is not.
That is not annexed. That is what I was also wondering. What is the demand letter?
It is not annexed. They have, because of that notification, they have just deferred it. And
would not be raised against the petitioner. With this direction, the writ petition is disposed of. Right.
Item 90.
The next one is same for the CSO. And the same.
Only that is IMFL, it is CS,
CS, country.
So same order, only the CSO you will change. Correct.
Pastor. Pastor matter item number 6.
Item number. Your Lordship. May I please, Your Lordship.
I am appearing.
Yes. Yes, Mr. Beura.
My lords, this is escape assessment order, my lord. There was no original assessment, my lords. It is covered by my lord's full bench judgment in Mr. Sekma's Regin's case, my lord. There was no original assessment, my lord.
I see. All right.
Escape assessment.
Yeah, that Mr. Mishra knows. I don't think he will dispute that.
Your Lordship, beginning I have stated, I have submitted that even though 2 question of law has been decided in favor of the state.
Correct.
But even after that, Your Lordship, because the last line of the order of the tribunal says so. And Your Lordship has already decided in the Tekmas resin.
Correct.
So that
where is that citation, sir? You have the judgment.
Where is that citation, sir? You have the judgment. My lord, WPC number 7458 of 2015 decided on 5/8/2022.
5/8/22.
Yeah.
In view of the judgment of this court dated 5/8/2022 in writ petition civil
7458 of
7458 of
2015.
2015.
Your Lordship, what I can pray, Your Lordship, both the question of law.
It's Keshav Automobiles.
No, Keshav Automobiles. It is anti-tax.
Oh, anti-tax.
ECMA's resin full bench.
ECMA's. In our case, Your Lordship, relating to section 10. OET. Section 10.
Yes.
The 2 questions
it's ECMA
state in these revision petitions do not survive for consideration and stand answered accordingly.
No, Your Lordship, these two questions, what happened, Your Lordship may kindly turn to page 22 of that order of the tribunal. Your Lordship, the tribunal, what the learning tribunal has done, learning tribunal on three issues. Number one is interpretation of the statute, so far as that SDP, PISNET, whether it is not coming under NT 23. No. Number two is that it is time barred. Number three is that in the last one line, Your Lordship may kindly 3 lines from the last paragraph. The Lawrence State representative during hearing of the case admitted that there was no assessment of anti-tax of the appellant previously. So, so these two questions are if Your Lordship will decide these first two questions, what have been raised in this revision, both the questions are in favor of the department, Your Lordship.
No.
So far as, let me complete. So far as the third question, which has not been raised and which has now been settled, for that reason, what I can pray, Your Lordship may dismiss my revision, but keeping open the question of law, what has been asked in the...
All right. I understand. You say, in view of the judgment of this court dated 5th August 2022 in Red Petition so-and-so, it is now settled that without an original assessment order, there cannot be a reopening of the assessment under the Orissa Entry Tax Act 1990. Full stop. On that short ground, this court upholds the order passed by the tribunal in the present case and leaves open for consideration the two questions urged on merits by the department in the present revision petition for decision in some other appropriate case. The revision petition is accordingly disposed of. That is 71 and 74 is the same order. Now 114 of 2013. So here this is
no, Your Lordship. This is of the petitioner. So far as that SDP PISNET, Your Lordship.
Oh, I see.
Your Lordship has already interpreted that NT 23, Your Lordship.
Right. Where is that?
And the tribunal, Your Lordship may kindly turn to the tribunal's order at page, Your Lordship, that page 2, internal page 2 of the tribunal's order. The paragraph 3.
Yes.
While dwelling on the point necessity relying on a full bench decision of the tribunal in the matter of which is the previous, which Your Lordship has dismissed, held that the goods like PISNET twine and PISNET fabrics are different goods from SDP twine, SDP, PISNET and PP rope, and as such cannot be treated as civil goods for levy of anti-tax. However, this view of the law and necessity is not correct, as goods like PISNET twine and PISNET fabrics are secondary products of SDP and PP rope. In municipal corporation, after the city of Thane and others versus Mako reported in one SEC, the Honorable Apex Court observed that when the expression of plastic goods and plastic powder is used along with the blacklight and backlight goods, and the manner in which the legislature uses this expression will clearly indicate that intention is to bring all kinds of plastic material with their, whether in primary form or in other secondary form. It has not been disputed that PISNET twine and rope are made of high quality polyethylene materials, and as such being secondary forms of SDP are definitely coming under NT serial number 23 and part 1 of civil goods prescribed under the OET Act and hence are accessible to entities.
Anyway, let him argue, sir. Let him best should interfere.
My lords, what I humbly submit, my lords, so far SDP, PISNET and other things are concerned, my lords, the present case, my lords, it is a distinct commodity, my lord. It is exempted item under the Orissa Sale Tax Act and exempted item under the Orissa Value Added Tax, my lord. Because to encourage the fishermen, my lords, there was an exemption given to the so far PISNET is concerned, and SDP, my lord, kindly see that
It's a different issue altogether. In fact, exemption is granted only if it is otherwise exigible to tax. Only then exemption will be granted. So that itself is an indication that it is otherwise exigible to tax.
my lord, this is in entry 23, my lord.
Yes, yes.
Entry
We've read that.
23.
Yes.
Kindly see. Polythene, high polyethylene, polypropylene includes wooden sack, plastic goods, molded luggage, excluding plastic or molded furniture, my lord. This is the entry 23, my lord. And so far, the present case is concerned, it is fishnet. Those are distinct different commodities as stated in other statutes also.
No, we are now on this statute, sir.
In this statute, my lords, this
is fishnet made out of HDPE.
HDPE is not what is, my lords, that is fishnet.
What is that fishnet material?
Material, my lords, this is plastic nylon.
Same thing.
Maybe
Polythene, it's high density polyethylene, all of that is the same thing, sir.
My lords, I'll bring my lords.
Yeah. Including woven sack plastic goods.
My lord,
so the rope will be a plastic goods, sir.
My lord, in Orissa Cell Tax Act, my lord, Orissa Cell Tax Act entry, list A, my lord.
So we have to interpret the entry in the OET Act. No point in going to the Orissa Sales Tax Act.
What I trying to convince my lordship is that this is a distinct and different commodity.
No. The entry is wide enough to include this, sir. The entry is wide enough to include this.
Even my lords, in that case also, my lords, here, my lords, there was no, this is the escape assessment. And there was assessment in this case.
That issue is not there. That issue is not here.
That is issue not there. My lord, kindly.
That issue is not here. Even though learned tribunal has set aside the matter.
My lord, what happened, my lord? First appeal was allowed. My first appeal was allowed. My lord, state preferred the second appeal of the tribunal. In that, that was allowed, my lord.
That's right. This is an SSC's revision petition arising from an order dated 1st August 2013 of the Sales Tax Appellate Tribunal, Cuttack, in essay number 150 ET /2012-13 filed by the state against the common order dated 30th April 2012 passed by the Joint Commissioner of Sales Tax, Puri Range Puri, in FA numbers 36/OET and 37/OET. For the tax periods 1st April 2005 to 31st March 2000, 1st April 2006 to 31st October 2006, respectively. The Joint Commissioner had reduced the demand for both periods by the assessing officer (AO) Jatni Circle by his assessment orders dated 10th May 2007. Paragraph. The question before the tribunal was whether tax could have been imposed, entry tax could have been imposed on scheduled goods like fishing net, fishing twine, and rope purchased from outside the state of Orissa. Also, one contention was that such goods could not be brought within the purview of serial number 23 of Part 1 of the scheduled goods under the OET Act. Paragraph. The tribunal has negated the above contention by holding that the fishnet, twine, and rope were in fact made of HDPE and polypropylene, and therefore were covered in entry 23 of Part 1 of the schedule to the OET Act. Full stop. A reference was made by the tribunal with the decision of the Supreme Court in Municipal Corporation Thane versus Macro Plastic Industries 1999 1 SCC 372. It is this finding that is sought to be assessed in the present revision petition. Paragraph. The submission of learned counsel of the parties have been heard. Full stop. Entry 23 of the schedule of Part 1 of the schedule to the OET Act reads as under. Reproduce entry 23. Let's put the flag here. The entry is wide enough to include all forms of single quotes plastic goods, apart from the main ingredient, which is polythene or high density polyethylene bracket HDPE, all polyethylene bracket PP. Full stop. The word single quotes including indicates the wide range of products that can be brought within this entry, which are made of either polythene, HDPE, or PP. We'll stop. The expression single quotes plastic goods also, unquote, is also wide enough to include all the secondary products of plastic of the above materials. We'll stop. What is only excluded is plastic or molded furniture. We'll stop. Paragraph. Consequently, the court finds no error having been committed by the tribunal in allowing the appeal of the state and holding that the product in question, that is fishnet twine, and fishnet rope made of HDPE, like PP, would, being the secondary form of HDPE and PP, would be covered under entry number 23 of Part 1 of the schedule to the OET Act and are exigible to entry tax at 1%. Paragraph. Consequently, the court declines to admit the reference by upholding the order of the tribunal. The revision petition is disposed of accordingly.
Gratefully obliged. Obliged.
Item 42. Pastor matter item 42.
None appears despite a passover.
My lord, we are appealing for the Union of India, my lord.
All right, dismiss for non-prosecution.
Item number 64.
None appears despite passover. Dismiss for non-prosecution.